Authors do not practice law and do not give legal advice. At no time do we check for legal. The authors and affiliates are not connected to the For Dummies brand, nor are we with any law firms, and its employees are not attorneys, nor are we affiliated or associated with attorneys. The authors do not practice law and do not give legal advice. At no time do we check for legal sufficiency, draw legal conclusions, provide legal advice, or apply the law to the facts of any particular situation. This publication should not be a substitute for the advice of an attorney. This is for educational and informational purposes only, in hopes to inform the reader of making a better decision, if any at all. Can a trust own an LLC? When protecting personal assets, you can save costs and avoid the probate process by putting your funds into a trust or an LLC. You can also combine the benefits of both. Here's how. What is a trust? A trust is a legally recognized relationship in which the assets of one party are held under state law on behalf of another party. Trusts are often used in estate planning in lieu of a will because putting assets into a trust can bypass the often costly and time-consuming probate process, the legal procedure for dividing up one's assets upon death. The most common type of trust is a living trust, which is created during the lifetime of the person who sets up the trust, known as the grantor. Living trusts usually fall into one of two categories: revocable, meaning the terms of the trust can be changed by the grantor; irrevocable, meaning the grantor no longer has control of their assets once the assets are placed into the trust. Can a trust own an LLC? Yes. The terms around LLC ownership are quite broad, allowing for individuals, other companies, or even living trusts to serve as LLC members or owners. A trust may hold an ownership percentage in an LLC or serve as its sole member. Why would a trust own an LLC? While it doesn't necessarily make sense for a trust to own a business, LLCs are often used as holding companies. In other words, people can form and fund an LLC that doesn't actually go into business, i.e., buy or sell products. Instead, the LLC structure is used to hold assets. The benefit of forming a trust-owned LLC is that it combines the limited liability protections of the LLC structure with the estate planning benefits of a trust, i.e., avoiding probate. This may be helpful when it comes to protecting certain assets within a trust. Real estate, for example, can be a potentially risky asset. But putting real estate investments into an LLC that is then owned by a trust effectively protects the other assets within that trust from the potential liability of those real estate investments. How do I transfer ownership of an LLC to a trust? To change the ownership of an existing LLC in any way, you'll need to change the terms of your LLC operating agreement and amend your articles of organization. If you're creating a new LLC with a trust as its sole member, you would simply include the name of the trust when completing your LLC formation documents. If you're considering a trust-owned LLC, it's probably a good idea to get in touch with a lawyer to make sure you have all your ducks in a row. Can a trust own an LLC? Everything you need to know. Can a trust own an LLC? This is a common question when business owners are deciding on which type of business entity they would like to form. The answer to the question is yes. Trusts are allowed to be owners of an LLC. What is an LLC? An LLC is a popular type of business entity that can provide shareholders with protection from liability while avoiding the subject of double taxation. In a limited partnership, there is also no double taxation, but the partners do not enjoy the limited liability. With both limited liability and more favorable taxation, an LLC is a popular choice for real estate. There is no restriction on the number of members of an LLC. Members can be both individuals and corporations. When it comes to tax purposes, a single-member LLC will have the profits from the company pass through onto their personal tax return. In multi-member LLC, Each member's portion of the profits will be reported on their Schedule K, which will then transfer to their personal 1040 return. During estate planning, investors can place personal assets in revocable living trusts which will pass to beneficiaries of the trust without the need to go through the scrutiny of a probate court. To determine which setup will work best for your trust, it is important to look at some of the popular options. Living trust as a sole member. The formation of an LLC provides limited liability protection, yet will not help with your estate planning. A living trust will aid you in your estate planning but won't provide you with any liability protection. An LLC with a living trust sole member will enjoy the best of both worlds with limited liability and the benefits of enjoying probate. Partnership and trust. An LLC can work as a sole proprietorship or partnership to gain additional tax benefits. In forming, you will protect your business assets over time, including property, bank accounts, and other personal assets from lawsuits. When forming a living trust, the property will avoid probate in the event of one of the partners' death, and the property will be transferred per your instructions. When creating an operating agreement for an LLC, it is vital to clearly define all of the ownership interest that is in a trust. Your operating agreement should include verbiage that the trustee or successor has the full rights as a manager or member of the LLC. A list of each manager and member of the LLC having a well-defined operating agreement is essential, as a financial or banking institution may not allow you interest in the business base in the event of a member's death or incapacitation without an operating agreement in place. Another benefit of putting membership interest in a trust is beneficial if the member's interest in the business will exceed the allowed amount to avoid probate. To find out if your interest will exceed the amount, or to find out if forming a living trust is best for you, consult an estate planning attorney. The legal status of living trusts. The legal status of your living trust will depend on how it is formed. A trust can be deemed revocable. In a revocable trust, the grantor can terminate the trust any time that they want to regain ownership. Because of this, the trust can be considered part of the grantor and will be deemed part of their assets in terms of debt. Irrevocable trust. When a trust is formed as irrevocable, the trust cannot be easily terminated by the grantor, but the assets will then be protected from creditors going after the grantor assets. Trust membership. The statutes of each state will authorize the trustees to be able to exercise legal owner rights over almost any asset an individual can own. Because the ownership interest in an LLC is considered an asset, it is possible for a living trust to become one of the members of the LLC. With all states now recolonizing single-member LLCs, it is possible for a living trust to be an LLC's only member. LLC Inheritance Agreement. Takeaway: it may be possible, through an LLC operating agreement, to direct who inherits a deceased member's interest in the LLC. Background: the use of LLCs has grown dramatically over the years by families with closely held business interests and investments, including commercial real estate. The LLC is a popular form of entity to hold business and income-producing assets due to its flexibility with regard to limitations on ownership, limitations and restrictions expressed in an LLC operating agreement. In some instances, an LLC can be looked at as a surrogate for an irrevocable trust, where the LLC manager acts in the role of a trustee, with duties of loyalty and care to the LLC member and with regard to decisions to the timing and amount of distributions from the LLC to its members. Restrictive operating agreements. However, many restrictive LLC operating agreements exist to prevent the transfer of a member's interest in the LLC to ex-spouses, in bankruptcy, to judgment creditors, or to others who are not members of the family or involved with the family business. The restrictions in the LLC operating agreement often come in the form of a right of redemption held by the LLC, or the right of first refusal to purchase a member's interest that would otherwise be transferred, either voluntarily or involuntarily. The problem with these restrictions is that they often impose a financial burden on the redeeming LLC entity, or its other members who exercise their right of first refusal to purchase the withdrawing or deceased member's interest in the LLC. While the remaining members want to control the identity of the new member, they would prefer to not have to scramble to raise cash to facilitate the redemption or purchase of the member's interest. This is especially the case when a member dies and the other members want to control the identity of the inheriting member. A couple of Florida court decisions seem to suggest that it may be possible in an LLC operating agreement to compel members to name an inheriting member of the LLC and effectively override the deceased member's will or revocable trust provision to the contrary. Bleckman v. Estate of Bleckman, 160 So.3d 152, Florida Court of Appeals, 4th District, 2015. This case dealt with whether the decedent's membership interest in the LLC was part of his probate estate. Facts: the LLC was owned by a brother and sister, each owning a 50% membership interest. Their LLC operating agreement contained restrictions on the transfer of membership interests without the prior unanimous written consent of the other member. One exception to this unanimous written consent requirement allowed the transfer to the member's living children and the issue of a deceased child, but not to parents, spouses, stepchildren, or paramours. On the death of a member, unless his/her interest passed to one of these identified individuals, the decedent's membership interest was directed to pass to the deceased member's then living children and issue of a deceased child, per stirpes, i.e. a default disposition. Despite this provision in the LLC operating agreement, the deceased brother by his revocable trust, which was funded with probate assets via his pour-over will, directed that his LLC membership interest and distributions from the LLC pass to his girlfriend. Dispute: the deceased member's children refused to give the LLC membership unit to the girlfriend along with the specified distributions. The decedent's children argued that the LLC membership interest passed according to the LLC operating agreement, and accordingly it was not a probate asset that passed to the revocable trust to be subject to the trust's terms. The children argued that the testamentary gift to the girlfriend was void. Court decision: the court found that New Jersey law governed the LLC operating agreement. It found that under New Jersey law, contracts transferring property on death, and supported by adequate consideration, are evaluated using contract law, and not the law that governs wills. The Florida court found that the LLC operating agreement was a contract that validly directed the disposition of the decedent's membership interest despite the terms of his revocable trust to the contrary. In effect, the court found that the LLC operating agreement could be used to ensure who will inherit a membership interest on the death of a member without the need to have a separate contract to make a will or the need to redeem or purchase the decedent's membership interest from a prohibited transferee. The court relied on Murray Van and Storage v. Murray, 364 So. 2D 68, 1978, in which that court held that an entity buy-sell agreement trumped a conflicting provision in a will. Finlaw v. Finlaw, 2D 19-3108, Florida Court of Appeals, April 16, 2021. Facts: this case dealt with an Ohio partnership in which the partnership agreement contained a provision where the partners agreed to have prepared and to execute a last will and testament so as to ensure that his or her interest in this partnership will, upon his or her death, pass to invest in his or her surviving spouse. Each partner, who shall ultimately become a surviving spouse, further agrees to have prepared and execute a last will and testament so as to vest his or her interest in this partnership in his or her children, lineal descendants. One of the 50% partners died in 2014 who executed a will that divides the remainder of her estate on her death to her grandson. She subsequently died a resident of Florida. Dispute: the decedent's son filed a claim in the Florida probate court asserting an entitlement to the partnership interest of his mother according to the terms of the partnership agreement. Court decision: the court, applying contract principles, found that the decedent's son was entitled to the ownership of his mother's interest in the partnership. Thus, the partnership agreement was in effect an inheritance agreement, an entity governing instrument. The court found, under both Ohio and Florida law, where contracting parties expressly agree on the disposition of property on death, that agreement generally controls over a testamentary disposition of property. The court seemed to ignore the fact that the mother failed to execute a last will and testament consistent with the terms of the partnership agreement. Nor did the court address whether the partnership agreement actually constituted a proper contract to make a will. Michigan's law on a contract to make a will is very short and to the point. If executed after July 1, 1979, a contract to make a will or devise, not to revoke a will or devise, or to die intestate may be established only by one or more of the following: a. Provisions of a will stating the material provisions of the contract. B. An express reference in a will to a contract and extrinsic evidence proving the terms of the contract. C. A writing signed by the decedent evidencing the contract. The execution of a joint will or mutual wills does not create a presumption of a contract not to revoke the will or wills. MCL 700.2514. Conceivably, a provision in a partnership agreement or an LLC operating agreement, if signed by a partner or a member, would satisfy the requirement of 1c of the statute and thus become a contract to make a will. Conclusion: it may be possible to control in an entity restrictive agreement the disposition of a membership or partnership interest on the death of a partner or member, perhaps without the need for a purchase or redemption of the decedent's interest in the LLC or the partnership. Such a provision might be appropriate in a family-owned and controlled entity. However, if such a provision is contemplated, consider giving the member/partner some latitude as to who they might leave their interest to on their death to avoid a completed gift of the remainder interest in the entity. Why you should consider putting your LLC into a trust. The Limited Liability Company, LLC, is a popular business structure that offers liability protection and avoidance of double taxation. Trusts are popular asset transfer vehicles that allow you to avoid probate and keep assets out of the hands of creditors. By placing LLC membership interests in a trust, business owners can combine the two types of legal entities and enjoy the best of both worlds. Transferring an LLC to a trust requires a bit of paperwork, and in multi-member LLCs, may also require the consent of other members. But a well-planned transfer can help reduce risks, keep your business affairs out of government hands, and fit into your broader estate planning goals. Benefits of placing LLC interests in a trust. Whether you own a single-member LLC or are co-owner of a multi-member LLC, your LLC ownership interests are considered personal property. Indeed, your business interests are probably one of your most valuable assets. As such, you will want to ensure that you are safeguarding your LLC now and have a plan for what will happen to the business when you are not around or can no longer manage your affairs. The following are some of the key benefits of placing LLC interests in a trust. Probate avoidance. Probate is the legal process of settling an estate when somebody passes away. Overseen by the court, i.e., the government, probate ensures that your debts are paid off and your assets, including business interests, are allocated to the beneficiaries you specify in your will. Assets that are placed in a trust generally avoid probate, which can take weeks or months to complete. During the probate process, there may be nobody managing your business interests, which can result in operational problems. Privacy. Not only can probate be lengthy and cause your business to languish, a probated estate is a matter of public record. That means anyone who knows where to look, example, creditors, disinherited heirs, and scammers, can learn details about your estate. Trusts, on the other hand, bypass probate, and the assets they contain pass to your beneficiaries more quickly, efficiently, and privately. Incapacity planning. You may have a plan for what will happen to your business when you die, such as having a trusted family member take over, or an agreement that allows other LLC members to buy out your ownership stake upon your death. But what happens if an accident or illness renders you incapable of fulfilling your business duties? If your LLC interests are held in a trust, the trust can be structured so that your incapacity immediately triggers the authorization of another person, i.e., the trustee, to take over on your behalf. Asset protection. Depending on the type of trust in which you place your LLC membership interests, the trust can make it more difficult for creditors to go after the trust assets. Types of trusts you can use for an LLC. The three main types of trusts that are commonly used with LLC asset transfers are revocable trusts, irrevocable trusts, and asset protection trusts. Each type has pros and cons for holding LLC assets. Revocable trusts, also known as living trusts, are trusts that can be changed or cancelled during the lifetime of the grantor, the person who establishes the trust. The grantor can name themselves as the trust beneficiary, the person who receives a benefit from the trust, as well as the trust's trustee, the person who has the right to manage trust assets, including any business interests. Using a revocable trust allows you to avoid probate, control the LLC, and receive income from the trust as the beneficiary during your lifetime. The trust can be set up in such a way that, upon your death or incapacity, a new trustee and a new beneficiary, or beneficiaries, are named. However, as long as you are still alive and maintain control over the trust assets could be subject to creditors' claims. Irrevocable trusts, unlike revocable trusts, cannot be changed or cancelled after they are created. The advantage of an irrevocable trust is that creditors cannot go after the assets of the trust's grantor. However, if an LLC is held in an irrevocable trust, the grantor loses access and control over the LLC, as somebody other than the grantor will presumably be named as trustee and beneficiary. This also means that the grantor loses any income from an LLC that is placed in a trust. Asset protection trusts, also called self-settled trusts, allow LLC owners to enjoy both the ownership and control benefits of a revocable trust and the asset protection benefits of an irrevocable trust. These types of trusts are highly specialized and quite complicated from a legal standpoint. Although they are required to be irrevocable, they can also allow you to receive distributions from the trust as the beneficiary and specify who will receive your LLC membership interests when you die. Not all states allow domestic asset protection trusts, but you do not have to be a resident to establish a trust in a specific state. Foreign or offshore asset protection trusts are another possibility. Other considerations for placing your LLC in a trust. Placing your LLC interests in a trust means that the trust, not you as the business owner, is legally an LLC member and a party to the LLC's operating agreement. Although the law permits a trust to own an LLC, the LLC operating agreement may not. Therefore, you will first need to check whether the operating agreement allows for this arrangement. Even if the LLC operating agreement permits trusts to be members, you may still need to obtain consent from the other members, assuming it is a multi-member LLC. Obtaining their consent could require a unanimous or majority vote, depending on the rules in the operating agreement. If you can proceed with the transfer of your LLC into a trust and have it become an LLC member, you will need to take the following steps. Transfer the LLC into the trust with the appropriate documentation prepared by an attorney. Update LLC documents, including the operating agreement, buy-sell agreements, and the articles of organization, to reflect the fact that the trust, not an individual, is now a member. Have the LLC members sign a resolution that formally recognizes the change of LLC ownership from an individual to a trust. This is not required, but it is a good business practice that can underscore the validity of the transfer of your LLC interests. What is the difference between a trust and an LLC? Trusts and limited liability companies, LLCs, are both legal vehicles that can be used to manage and protect assets, minimize taxation, and avoid probate. Whether a trust or an LLC is a better choice may depend on the type of asset, but you do not necessarily have to choose between the two. In fact, an LLC can be placed in a trust. To explain how that works, it is first necessary to better understand each type of entity and clear up some common misconceptions about them. What is a trust? When most people think of a trust, they think of a vehicle for transferring intergenerational wealth. While this is not too far off the mark, trusts are not exclusively for the wealthy. They are, however, a common way to avoid probate, the legal process of settling an estate when somebody passes away, and planned for estate taxes. For starters, it is not just money that can be placed in a trust. Trusts can hold cash, but they can also hold other assets such as bank accounts, securities, life insurance policies, real estate, intellectual property, personal possessions, cryptocurrencies and non-fungible tokens, NFTs, real estate, and ownership interests in a business, including an LLC. This is not a complete list of what you can put in a trust. The ability to transfer title of an asset to a trust does not mean that it is the best place for it. Before placing any asset in a trust, consult an attorney about how the transfer might affect taxation, liability protection, and probate. Once you have decided that certain assets belong in a trust, the next step is to create the trust. You will need to specify the assets to be placed in the trust, somebody to oversee the trust assets, a trustee, the individuals who will receive the trust assets at the specified time, the trust's beneficiaries, and instructions for distributing trust assets to beneficiaries, the trust agreement. In addition, you will need to fund the trust by transferring title of the assets into the name of the trustee. You will also have to choose the type of trust. A revocable trust is more flexible and can be changed during your lifetime, whereas an irrevocable trust cannot be changed once created. A testamentary trust can be created at the time of your death per instructions in your will. A key feature of trusts is that once your assets are transferred into the trust, they technically are no longer your personal property. They are the property of the trust, which is managed by a trustee for the benefit of the beneficiaries. This explains why some trusts can help minimize or avoid estate taxes. Also, because assets in a trust are not part of your estate at death, they do not have to be transferred to your heirs through the probate process. They are instead distributed according to the trust terms. What is an LLC? An LLC is a type of business entity that provides liability protection to its owners and avoids double taxation. In terms of liability protection, when an LLC takes on debts and liabilities, its owner's personal assets generally cannot be seized by creditors of the LLC as payment for what the business owes. LLCs also are not taxed at the corporate level. Instead, LLC owners pay taxes on business profits on their personal income tax return. This avoids the double taxation applicable to corporations. LLCs, like other businesses, have assets such as real estate, vehicles, tools, equipment, and intellectual property. And like a trust, just about any type of asset can be transferred into an LLC, including personal assets like cash and bank accounts, property, and personal possessions. Thus, LLCs can also serve as tools in the estate planning process. Applicable to corporations. LLCs, like other businesses, have assets such as real estate, vehicles, tools, equipment, and intellectual property. And like a trust, just about any type of asset can be transferred into an LLC, including personal assets like cash and bank accounts, property, and personal possessions. Thus, LLCs can also serve as tools in the estate planning process. To start an LLC, you file the Articles of Organization with the Secretary of State where the business is located. That could be your home state, but you can start an LLC in any state. If you are primarily looking for asset protection, then it might pay to shop around in different states. Nevada and Wyoming have statutes providing strong asset protection. An attorney can help you identify the right state for your unique needs. Most states also require you to file a report at least once per year. At startup, you pay a one-time filing fee. When filing an annual or biannual report, expect to pay approximately $100 to $500 per filing. The other major document for your LLC is the operating agreement. While it must comply with state LLC laws, the operating agreement typically does not have to be filed with the Secretary of State. This document specifies the LLC's internal rules and procedures. Although it is not always advisable, you can stipulate in the operating agreement that, when you die, the business passes to your heirs, or the income from the business goes to your kids. It is important to check with your attorney to ensure that you have carefully thought through all of the ramifications, for example, whether the heirs are prepared to become business owners and if this plan is acceptable to any existing business partners. Similar to a trust, transferring the LLC interests to beneficiaries can be a way to avoid probate. Not only can you manage and pass on a family business through an LLC, you can also place assets in the LLC, such as rental properties and vacation homes. In fact, just about any asset can be placed in the LLC, including money and personal possessions. Those with large estates can use a family LLC structure to minimize gift and estate taxes. Is a trust or an LLC right for you? To summarize, trusts and LLCs both have value as legal instruments that can shield assets from taxation and avoid probate. LLCs have the added benefit of personal liability protection, but they typically have higher ongoing costs than trusts. One benefit of those higher costs is that you have a greater ability to manage the assets in an LLC. As noted, once you place assets in certain types of trusts, they are out of your hands. But there is a trade-off with regard to privacy. Trusts never become part of the public record, while the existence of an LLC, though not necessarily the identity of its members, depending on your state's law, is public information. Some trusts and LLCs, when set up correctly, have the potential to protect assets from creditors. With trusts, you have to be careful to choose the right type of trust for maximum creditor protection. Even then, there is no guarantee that your beneficiaries will be completely protected. LLC asset protection varies by state, and care must be taken to treat the LLC's assets separately. From your personal property to keep creditors from being able to pierce the veil of the LLC and come after your personal assets. In short, there are trade-offs associated with using either a trust or an LLC. One common way to minimize these trade-offs is to place an LLC inside a trust. If a trust owns an LLC, it adds another layer of asset protection. In addition, one way to avoid having your name on state registration documents is to hire a third party to form the LLC for you and act as your registered agent. Why you need a trust. Although many people equate estate planning with having a will, there are many advantages to having a trust rather than a will as the centerpiece of your estate plan. While there are other estate planning tools, such as joint tenancy, transfer on death, beneficiary designations, to name a few, only a trust provides comprehensive management of your property in the event you can't make financial decisions for yourself, commonly called legal incapacity, or after your death. 1. Avoid probate and keep matters private. One of the primary advantages of having a trust is that it provides the ability to bypass the publicity, time, and expense of probate. Probate is the legal process by which a court decides the rightful heirs and distribution of assets of a deceased through the administration of the estate. This process can easily cost thousands of dollars and take several months to more than a year to resolve. Of course, not all assets are subject to probate. Some exemptions include jointly owned assets with rights of survivorship as well as assets with designated beneficiaries, such as life insurance, annuities, and retirement accounts, and payable upon death or transfer on death accounts. But joint tenancy and designating beneficiaries don't provide the ability for someone you trust to manage your property if you're unable to do so, so they are an incomplete solution. And having a will does not avoid probate. Of note, if your probate estate is small enough or it is going to a surviving spouse or domestic partner, you may qualify for a simplified probate process in your state, although this is highly dependent on the state where you live and own property. In general, if your assets are worth $100,000 or more, you will likely not qualify for simplified probate and should strongly consider creating a trust. Considering the cost of probate should also be a factor in your estate planning, as creating a trust can save you both time and money in the long run. Moreover, if you own property in another state or country, the probate process will be even more complicated because your family may face multiple probate cases after your death, one in each state where you owned property even if you have a will. Beyond the cost and time of probate, this court proceeding that includes your financial life and last wishes is public record. A trust, on the other hand, creates privacy for your personal matters as your heirs would not be made aware of the distribution of your assets, knowledge of which may cause conflicts or even legal challenges. 2. Provide ongoing financial support. A common reason to create a trust is to provide ongoing financial support for a child or another loved one who may not ever be able to manage these assets on their own. Through a trust, you can designate someone to manage the assets and distribute them to your heirs under the terms you provide. Giving an inheritance to an heir directly and all at once may have unanticipated ancillary effects, such as disqualifying them from receiving some form of government benefits, enabling and funding an addiction, or encouraging irresponsible behavior that you don't find desirable. A trust can also come with conditions that must be met for the person to receive the benefit of the gift. 3. Take care of yourself if you get incapacitated. Furthermore, if you ever become incapacitated, your successor trustee, the person you name in the document to take over after you pass away, can step in and manage the trust's assets, helping you avoid a guardianship or conservatorship, sometimes called living probate. This protection can be essential in an emergency or in the event you succumb to a serious, chronic illness. Unlike a will, a trust can protect against court interference or control while you are alive and after your death. How to choose a guardian for yourself. Every day we make hundreds of decisions, from what to eat for breakfast to where we go on vacation. With each passing day, there are more choices to be made. But what will happen if you can't make decisions for yourself? Before that time comes, there is one important decision you need to make. Who do you want to serve as your guardian? You may want one person or want different people to serve in various capacities. Here is a brief look into two types of fiduciaries who can act. Power of attorney, general/financial. With a general or financial power of attorney, you are authorizing someone to handle your financial affairs, sign checks in your name, open up a bank account, enter into contracts on your behalf, sell or acquire real estate, etc. This can be very beneficial because if you are no longer able to do these things for yourself, someone else can immediately step in and do them for you. However, you may run into situations in which third parties are going to want the person to have more authority than just assigned power of attorney. In these cases, they are going to require you have a guardian appointed. Guardian. A guardian is essentially a court-appointed and court-controlled agent. They have the court's authority to handle your financial affairs on your behalf if you cannot. In many jurisdictions, the court will give priority to an individual who has been named as agent under a power of attorney, making it incredibly important that you have one prepared. If you do not have one, each state will have a law that lists the order in which people are appointed. In some cases, you could end up having someone handling your affairs that you would have never wanted, like an estranged parent or sibling. Stay in control even when you are incapacitated by selecting your guardian in advance in your estate planning documents, in the event of your incapacity, whether temporary or long-term. To ensure that you are taken care of when you can no longer take care of yourself, it is important that you choose the right person. When analyzing the pool of candidates, consider the following. Questions. Does he or she have the time to act as your guardian? Oftentimes, those individuals who are the most organized and knowledgeable to help out are also the most heavily scheduled individuals and may not be able to step in. Does he or she live close by? Even in our digital world, some issues may take multiple steps or in-person interactions to resolve. If the individual you are looking to appoint lives far away, he or she may not be able to fully carry out their duties. Does he or she have the skill set needed? When acting as a guardian, it is crucial that the individual is organized, thorough, and can communicate clearly. A person who is scattered or flies off the handle easily is not going to be a good advocate for you. While we all want to retain as much autonomy as possible, there may come a time when we need someone to act for us. Selecting the right individual will ensure that you are taken care according to your wishes. Blended family concerns handled by a well-drafted trust. Whether you are in your first marriage or have remarried after a divorce, blended families are a common part of modern society. That being said, it is important to understand that blended families and subsequent marriages create important and unique issues when it comes to estate planning. You may need to account for a prior spouse who is still caring for minor or disabled children, and also possibly make sure your current spouse and any children you had together, and any stepchildren, are also taken care of after you pass away. The good news is that estate planning can take all of these factors into account. This is true whether you are putting together your estate plan for the very first time or if you need to update your current estate plan due to a change in your circumstances. Setting up a trust. It is common for married couples to leave everything to one another in their wills, or list their spouse as the sole beneficiary of any assets that allow for this designation. The result is that if one spouse passes away before the other, the surviving spouse will own all of the assets left behind outright. While this may work for some families, when it comes to blended families, this strategy may inadvertently disinherit children or spouses from a prior marriage. One way to provide for a current spouse without leaving out children from a prior marriage is to place some or all of your assets in a trust that the spouse can use during his or her lifetime. Once the spouse dies, all of the property in the trust can go to the children from your current and prior marriage, or to other intended beneficiaries. Beyond simple beneficiary designation, the plain and simple beneficiary designation on assets, like life insurance, bank and investment accounts, etc., that allow for outright distribution to the surviving spouse can inadvertently wreak havoc on an estate plan when a blended family is involved. These complications can apply to a couple who has children from prior marriages, someone who remarries late in life, or someone on their second or third marriage and beyond. For example, you may purchase a large life insurance policy and designate your current spouse as the sole beneficiary and pass away shortly thereafter. Since the beneficiary designation takes precedence over your estate planning documents, the proceeds of the life insurance will not be placed in that trust and will be distributed outright to your current spouse. If you had instead named the trust as beneficiary, you could have determined when and how the funds would be spent for the benefit of your heirs. As an example, the funds could be used to provide support for your surviving spouse during his or her lifetime, while also allocating a portion to help your children to pay for college, finance a down payment on a first home, pay for a wedding, or start a business. The key is that the money can be available for your spouse, but not with unfettered control, and still available for your children. Ensuring your wishes are followed. While you hope that a surviving spouse would honor your wishes even if they are not in writing, you may accidentally disinherit your children. Instead, a knowledgeable estate planner will use your trust as the centerpiece of your estate plan and make sure to coordinate and align the beneficiaries on your assets so that your intent will become the reality once you have passed away. Avoiding probate deed transfers. Property is valuable, and protecting the ownership of your property is important, even after you die. Family members are sometimes left needing to figure out how to effectively and legally, in the most cost-effective way, transfer title to the property after the death of the owner. I want to discuss deed transfers because it is a very cost-effective solution and it avoids probate. Your property and probate. Probate is the legal process that deals with the estate of someone who has died. The probate court will determine the validity of a will and appoint an executor who will have the legal authority to distribute your assets to your beneficiaries. If you die without a will, known as intestate, the probate court will determine how the estate should be handled based upon state laws and regulations. Many people don't understand that, even when you have a will, probate can be a time-consuming and expensive process. Depending upon how complex the matter is, whether or not all the siblings, heirs, or other beneficiaries agree with the will, you may need to get a probate attorney. A lot of people simply can't afford an attorney, nor can they afford to take time off from work to show up to court. Legal fees and court costs can be cost-prohibitive depending upon the length of the matter. One way to avoid entangling your property in probate is to use a deed transfer. Transferring the title of the property to someone else or adding someone else to title to the property. A deed transfer is a written and signed legal document that is used to transfer ownership of the property from the previous owner, the grantor, to the new owner, the grantee. Why use a deed transfer? A deed transfer can be used to change the title of the property to an individual or entity and can also be used to add or remove individuals or entities from the title. For example, I may own a property by myself, and if I want to add my husband to the title of that property as well, I would do a deed transfer. Let's discuss some of the ways in which you may need to use a deed transfer. As I mentioned earlier, one way is you may need to add or remove someone to the title. In the event you have gotten married or divorced, you may need to add or remove a spouse. An aging parent, someone with a chronic health condition like Alzheimer's or dementia, may want to add an heir to the property title. Others with ongoing trauma, a long-standing health condition, or a terminal condition might also want to add a spouse, significant other, or sibling, for example. In most of these cases, people want some assurance that when they pass their property is just not up in the air for anybody or everybody to claim. There is no arguing because ownership of the property goes to the person on the title. Sometimes, people just want to add someone to the title as a safety and a security measure in case something does happen. People like first responders or active military personnel going off to war or overseas may want to have someone on the title, just in case. Sometimes, you just want to have a certain person on the title because the property is a gift that you want to give them, and then you can avoid tax fees, probate fees, and other transfer fees. Transferring your property to a non-profit by deed transfer is another option some people want. A lot of people want their church or nonprofit that they've dedicated their life to or that they really believe in what the mission value of the nonprofit is to have ownership of their property after they pass on. Many nonprofit organizations have particular rules and regulations regarding property donations, so it's a discussion that you need to have with the organization beforehand. If your building or your property has a mortgage on it that the nonprofit is going to have to pay upon your passing, that may create a burden on the organization. Have a discussion with a nonprofit or a church prior to planning to do a transfer, because they could deny the transfer of the property if it can be more of a burden than a blessing to them. All of the ways that I've given you so far are situations where the deed transfer is done before someone dies. After someone dies, if there's no will, then the heirs can transfer the property to themselves, or the heirs may want to sell the property without having to go to probate. I mentioned earlier, without a deed transfer, your property could end up falling into probate court. In addition to having to pay a bond, you have to pay legal fees to an attorney if you're unable to navigate probate court by yourself. You may have to take time away from your job to go to court dates. Matters can get very complex if siblings or heirs are fighting over the property and proper ownership, or fighting over who exactly is an heir. Property and money upon somebody's death, unfortunately, makes some people go kind of crazy. In the past, when you had to go to probate, a lot of communities of color were losing that legacy that people have fought so hard to purchase. Since they couldn't afford to go to probate court to then dispose of the property appropriately, then it was just left there. Preparing a deed transfer. The information on a deed transfer is tracked and recorded by the county recorder's office. When ownership of the property is transferred from one owner to another, a new deed is filed with the recorder of deeds. A deed transfer is the official record of ownership, and properly recording any transfers of property is very important. You need to submit the correct official documents to reflect the transfer. Without the required documents, the transfer could be invalidated. In addition to the deed transfer, you may also need a few other documents. For example, you might need an affidavit of heirship. This affidavit is a notarized statement from either an heir or someone who knows the situation with the heirs, that these are the heirs. All possible heirs will be listed, including children out of wedlock, adopted children, children of heirs that may have predeceased the property owner. The purpose is to determine the lineage, giving a statement of fact as to who is an heir. Additionally, you have to fill out a statement by grantor and grantee. This document is also notarized and states that both the grantor and the grantee are real people or entities recognized by the state of Illinois. That is a brief look into the current process to handle a deed transfer. As you can see, a deed transfer is a much quicker, more efficient, and a more cost-effective way to transfer property, as opposed to going into probate court. Using deed transfers has really enabled families, communities of color to keep the legacy going, to hold on to the property that they otherwise may not have been able to hold on to, due to the cost-prohibitive and time-consuming nature of going to probate court. Getting it done right. The type of deed you need to transfer property can vary. The deed may contain conditions or assurances that go along with the transfer. Your specific situation will determine which type of deed is right for you. I understand that estate issues, finances, property, and death are very sensitive topics and can be very emotional. It can be a very trying topic because it can bring out some family issues that not all families are proud of, and trust me, I have seen the gamut. I have seen families who are fighting. I have seen families that are very peaceful. Whatever your particular situation is, it's not lost on me, but allow me to help you navigate that for the best resolution for the family and the property owner. I've helped with several deed transfers in many different situations. Let's have the conversation to determine your family needs. Whether the property owner is still living or if they have passed away, a deed transfer can be an excellent way to reduce costs and reduce the amount of time that you have to spend on this particular matter. Do I need a will? A quick guide to securing your legacy. Most people think of a will as one of those rich people things that does not apply to them. In contrast, others believe they need a will for everything they own. So, what exactly is a will, and how do you know if you need one? A will essentially outlines the distribution of your items or assets upon your death. Most people put their property and business assets in their will, but this is not always the best idea because wills have to be probated. However, several other options can ensure that your wishes are respected. The goal is to transfer your assets outside of probate so that your heirs do not have the expense or time consumption that a probate court will cause. I always tell clients to make a list of their assets. A typical person has one house, 1 or 2 cars, a bank account, and possibly a brokerage account such as retirement or some other stock account. Once we write these items down, we want to dispose of each one outside of your will to avoid the need for probate. Time-saving alternatives to a will. Avoid statements like, I leave my house to Johnny Mac or I leave my bank account to Susie May on your will. Leaving that in a will means it must be probated before it's finalized. Instead, you want to transfer the title of your assets while you're alive or posthumously, and there are ways to do that without going to probate. Alternative number 1. transferring ownership of your house. You can transfer the title to your house outside of probate through a deed transfer. This means you can transfer ownership of your house to a person of your choosing. Alternatively, you can add that person to your deed so that they automatically get the house when you pass on. This means they don't have to go to probate court because their name is already on the deed. Another option is getting a transfer on death, toady deed. This is a form that states where you want your property to go upon your death. The form is recorded in the county office where your property is located. Upon your death, the person only needs to fill out an affidavit and have it recorded that they accept the title to your property. Much like the deed transfer, a toady does not require probate court. Alternative number 2, giving access to your bank accounts. Bank accounts also do not need to be in your will. If you have money in your account, you can have your bank put a payable on death (POD) order on the account. Upon your death, the person specified on your POD gets access to your bank account. You can also put someone on your bank account as an authorized person. And I know that scares a lot of people because they worry about losing their money. So, a POD is probably a better option. Alternative number 3, using a trust. You can put your property in a trust and designate beneficiaries to that trust. The trust will remain intact after your death, and beneficiaries will then own the property. You can also put beneficiaries on your bank, retirement, or brokerage accounts. Even IRAs have beneficiaries. So, make sure your beneficiary paperwork is up to date. The person you designate as your beneficiary will get the funds in that account outside probate. They'll only need to file the requested forms from the brokerage or retirement company to access those funds. The only things left to go in your will after you transfer these big-ticket items are personal items like clothes, memorabilia, and jewelry. You don't necessarily have to probate those items because nobody's going to spend thousands of dollars to probate where your clothes go, unless you are Prince or another celebrity. The designated executor of your estate should give these smaller items to the people named in your will if they want them. That way, your family won't endure the expense and time associated with going to probate. The biggest things people fight over are houses, bank accounts, and retirement accounts. Once you dispose of those according to your wishes while you're alive, there's nothing left for families to fight over. Take it from me, I have seen it all too often. Death brings out the worst in people. To keep all the clamor down, determine who you want to have your assets while you are alive. Title requirements for trust and operating agreements. Many property owners choose to hold title in trusts. It is also not unusual for limited liability companies, LLCs, to hold title to property. While these are common ways to hold title, the requirements for transferring title need to be followed carefully to ensure property vests correctly, both to ensure the marketability of title and to avoid future legal consequences. Trust agreements in Colorado. There are 2 ways for a trust to take title to real property: in the names of the trustees of a named trust or in the name of the trust itself. In both instances, a statement of authority must be already recorded, or recorded with the vesting deed. According to Colorado statute, the proper way to evidence the existence of a trust is by recording a statement of authority. The statement of authority contains the following information: the name of the trust, the state under whose laws it was created, the mailing address for the trust, the name and position of the persons authorized to execute instruments affecting title to real property on behalf of the trust. The statement of authority must be recorded in the county where the property is located. When ensuring a transaction with a trust as the seller or buyer, the title company will require review of relevant portions of the trust agreement to confirm the names of the trustees authorized to act on behalf of the trust and the accuracy of the statement of authority. If the trustee of a trust is deceased, incapacitated, or unwilling or unable to act on behalf of the trust agreement will be relied upon to determine who can act as the successor trustee. The closing may be delayed if the proper people are not available to sign the documents as specified in the trust agreement. A new affidavit or statement of authority must be executed and recorded if there is any change to the trust agreement, including withdrawal of a trustee, addition of a trustee, or death of a trustee. If no trust affidavit or statement of authority exists for how title is vested, the title commitment will show a requirement for a statement of authority to be recorded at closing to place evidence of the trust's authority on record. Operating agreements. The existence of a limited liability company is determined by the stamped articles of organization filed with the Secretary of State. The authority of the members and managers to bind and convey real property is determined by the operating agreement. When insuring a transaction with an LLC as the seller or the buyer, the title company will require review of the relevant portions of the operating agreement. This review is vital to confirm which manager or manager/member can execute instruments affecting title to real property on behalf of the LLC. For limited liability companies without an operating agreement, all members and managers will need to sign the closing documents. If there is no operating agreement, or if circumstances require deviation from the terms of the operating agreement, the title company will require a statement of authority to be recorded. The statement of authority contains the following information: the name of the LLC, the state under whose laws it was created, the mailing address for the LLC, the name and position of the persons authorized to execute instruments affecting title to real property on behalf of the LLC. The statement of authority must be recorded in the county where the property is located. It is imperative that all documents be signed in accordance with the directives in the operating agreement. If the proper people are not available to sign the documents, the closing may be delayed. The Corporate Transparency Act explained. The Corporate Transparency Act, CTA, which will go into effect on January 1, 2024, was enacted by Congress as part of the Anti-Money Laundering Act of 2020. Because of this act, most smaller LLCs and corporations, limited partnerships, and trusts will need to file an information report with the Financial Crimes Enforcement Network, FinCEN, starting in 2024. No business owner enjoys being saddled with a new bureaucratic requirement, but since the CTA is going to be an unavoidable hassle for many business owners and investors, we wanted to explain in straightforward terms what the Corporate Transparency Act is, who needs to report, and what the requirements are. What is the Corporate Transparency Act? The Corporate Transparency Act is a new law requiring U.S. corporate entities and non-U.S. entities that do business in the United States to report ownership information to FinCEN. The purpose of the law is to prevent bad actors from using anonymous U.S. companies to stash money for illegal purposes, such as money laundering, terrorism, and fraud. Starting in January 2024, newly formed companies will have to submit a Beneficial Ownership Information (BOI) report to FinCEN within 30 days of formation. Companies formed before January 1, 2024 have until the following year, January 1, 2025, to report. Entities that are required to file this report are referred to as reporting companies in the CTA. There are exemptions to the requirement, which we'll get into below. Beneficial Ownership Information Report requirements. Let's go over who has to file this report, what the exemptions are, and what information is required. Who is required to report? The following entities are considered reporting companies, unless they qualify for an exemption: U.S. LLCs, U.S. corporations, other U.S. corporate entities, including limited partnerships and trusts, foreign entities that do business in the U.S. Who is exempt from reporting? According to the Beneficial Ownership Information Reporting Requirements, there are 23 categories of exemptions from this requirement, including large operating companies that have 20 or more full-time employees, had more than $5 million in gross receipts during the previous tax year, and have an office in the U.S. Publicly traded companies that issue securities and are regulated by the Securities Exchange Act. Money services businesses registered with FinCEN, such as banks, credit unions, and foreign currency exchange businesses. subsidiaries of some exempt entities, investment companies, investment advisors, and venture capital fund advisors that are registered with the SEC, commodity pool operators and commodity trading advisors registered with the CFTC. It's important to note that while registered investment advisors are exempt from the reporting requirement, private investment advisors are not. Certain commodity pools and other investment vehicles are also not exempt from this requirement. If you're not sure whether or not your business is exempt, it's a good idea to consult an attorney. What information do I need to report? Reporting companies need to disclose some basic information about the business entity, as well as information about all beneficial owners of the company. A beneficial owner is defined as any individual who either has substantial control over the company or who owns or controls at least 25% of the ownership interest in the company. Here's the company information required in the BOI report: entity name, plus any DBAs, business street address, no PO boxes, registered agent addresses, or mail forwarding/virtual office addresses allowed, jurisdiction where the business was formed, for foreign entities, the U.S. jurisdiction where the business is registered, tax identification number, such as an EIN for each beneficial owner. You'll need to give the following information: legal name, birth date, residential address, a photo of an acceptable identification document, such as a driver's license or passport, and the ID number from the document. When you file, you may request a FINCEN identifier, which is a number you can use on future filings with FINCEN rather than submitting the above information again. Who is considered a beneficial owner? As mentioned above, a beneficial owner is an individual with either 25% ownership interest in the company or substantial control over the company. The CTA criteria for having substantial control are deliberately vague to account for companies with unconventional leadership structures. According to the CTA, a person is considered to have substantial control if she or he is a senior officer, such as a CEO, CFO, president, etc., has the authority to remove a senior officer or a majority or dominant minority of the board of directors, directs, determines, or has substantial influence over important decisions within the company, has any other form of substantial control over the company. People who are exempt from being reported as beneficial owners include minor children. Parent or guardian information is required instead. Employees who act in the company only as employees and who are not senior officers. An individual acting as a nominee, intermediary, custodian, or agent for a beneficial owner. An individual who has only a future interest in the company through a right to inheritance. A creditor of the company. Who can see the information I report? FINCEN will have the authority to share information in your report with U.S. government agencies, state, local, and tribal law enforcement agencies, financial institutions for the purpose of verifying customer identity. The information on the BOI report will not be accessible to the public and won't be subject to Freedom of Information Act requests. How to file the BOI report. FINCEN is currently building a web system called the Beneficial Ownership Secure System, which is not yet available. Once the reporting requirement goes into effect in January 2024, you'll be able to submit your BOI report using this online system. When do I have to file? If your company was formed before January 1st, 2024, you have until January 1st, 2025 to file your first BOI report. For companies formed on or after January 1st, 2024, the BOI report must be filed within 30 days of receiving notice that your company was successfully formed or registered. Will the BOI report need to be updated? Yes. If there are any changes to the information reported, you'll be required to file an updated report no more than 30 days after the date of the change. Some changes that would need to be reported include transfers of ownership interest, changes in the names, addresses, or identifying numbers of beneficial owners, the company becoming exempt from reporting requirements. What happens if I don't report? The Corporate Transparency Act states that a company that willingly fails to report or that provides false or incomplete beneficial owner information can be charged with harsh penalties, including fines and up to a 3-year prison sentence. While the law says that the failure to report has to be willing in order to receive these penalties, it's still a good idea to take this law seriously and file your report on time if required. Real estate, creating an LLC for a revocable trust. When it comes to asset protection, you can create an LLC or a trust to hold your real estate investments. Both options have benefits and drawbacks. However, another possibility is to create an LLC that's owned by a revocable trust. Can a trust own an LLC? Yes. You may form an LLC with a revocable trust as its sole member. Unlike an irrevocable trust, which cannot be modified by its creator after it's been formed, a revocable trust allows the grantor more control over assets. What's the difference between a trust and an LLC? Trusts and LLCs are both legal entities that can hold assets, but there are several key differences when it comes to privacy, asset protection, cost, and probate, the legal process for distributing assets. But the basic differences are, a trust is like a lockbox that holds assets for the benefit of another and can't easily be tampered with once it's been created. An LLC is a business structure that operates like a partnership, with minimal oversight, but benefits from liability protection. Like corporation, LLCs can hold assets, like a trust, but they allow owners more oversight and flexibility. Why create an LLC in addition to a revocable trust? Combining the LLC model with a revocable trust can give your assets an extra layer of protection, and can also help you avoid probate, the legal process of distributing assets. The idea is that you'll get limited liability protection for your assets and help your beneficiaries more easily navigate the probate process, which can be lengthy and costly. That said, forming an LLC comes with its own costs and might infringe on your privacy. Whether you choose to hold your real estate investments in an LLC, a trust, or a combination of the two depends on your unique circumstances. Starting your own law practice in New York. When you decide to create your own law firm, you're not only tasked with finding clients and cases, you'll need to decide how to run your business. The main considerations you'll have to make concern cost and liability. What are my options for forming a New York law practice? It depends on whether you plan to start a practice on your own or with a partner or partners. But generally, your options include 1. Sole proprietorship benefit, no startup costs, and you won't have to file any paperwork with the state. Downside, business finances will be integrally tied to your personal finances. 2. Limited liability partnership, LLP, benefit, each partner receives liability protection from one another. Downside, if the LLP is sued as a whole, each partner's assets are at stake. 3. Professional corporation, PC, benefit, limited liability protections for all corporate employees, and tax advantages. Downside, expensive to set up and maintain. 4. Professional limited liability company, PLLC. Benefit, limited liability protections. Downside, more oversight than an LLP. Why can't I form a New York LLC for my law practice? Some states, New York included, require certain licensed professionals, like doctors, lawyers, and accountants, to set up their businesses as professionals. Instead of an LLC, for example, they would set up a PLLC. Both LLCs and PLLCs offer limited liability protections when it comes to business matters. The main distinction is that employees of PLLCs are still liable for malpractice or negligence as a licensed professional. Wait, what does it mean to be a professional? According to New York LLC L Section 1201, A professional is any individual duly authorized to practice any of the professions included in this list from the New York State Education Department. This includes licensed physicians, attorneys, and counselors at law. Asset protection, the corporate veil and charging orders. You can plan in such a way that increases your potential to protect your assets and property from creditor claims. This type of planning must start long before you need it, and learning about the possible ways that a business entity can help you with asset protection planning is a great place to start. A business entity like a corporation or limited liability company, LLC, will help protect you in two ways: corporate veil protection and charging order protection. However, you must properly set up your business entity for this protection to function properly. You must also maintain your business and follow any necessary formalities as required by state law. What is asset protection? Many people assume that asset protection planning is just another term for hiding your assets from creditors, but that is not the case. Instead, asset protection operates well within the confines of the law. It is smart and completely legal. Proper asset protection will help you keep your property safe from creditors. These creditors may hold any type of debt against you, including debt from simple outstanding invoices to large civil judgments from a lawsuit. Anyone can end up facing a lawsuit that can cost them thousands of dollars, regardless of whether or not you own your own business. Someone can easily get hurt on your property, or you may cause a car accident, resulting in a costly legal battle. If your insurance company denies you coverage, you may be on the hook for the injured party's medical bills, lost wages, pain and suffering, and a lot more. Proper asset protection planning helps you avoid losing some of the most important and valuable property that you own. Starting the asset protection process. While asset protection planning is completely legal, you must initiate the process long before you actually need it. If you start moving assets after litigation starts or on the eve of trial, you are going to have problems. Transferring assets out of your name with the intent to hinder, defraud, or delay a particular creditor is illegal. These are called fraudulent transfers. While the term is often associated with bankruptcy, state laws have their own version of what constitutes a fraudulent transfer or fraudulent conveyance. The definitions are very similar. Instead, you should begin planning for asset protection as soon as possible, just in case you need it. It is never too early to get the process started. Proper planning can help you keep some of your most valuable assets and protect your business as well. The corporate veil, the basics. Corporations and LLCs are separate legal entities. They can enter into contracts on their own, and they can incur debt by themselves. They also have their own legal responsibility for their actions. Due to this separate legal status, owners and shareholders are generally not liable for obligations of the corporation or LLC. Instead, their liability is limited to the investment that they have provided to the enterprise. This limited liability is often referred to as the corporate veil. The corporate veil protects owners and shareholders' assets from the obligations of the company, so they are not personally liable for contracts, debts, or even lawsuits against the business. Piercing the corporate veil. The liability protection that corporations and LLCs provide is not absolute. Instead, a creditor can pierce the corporate veil and make owners or shareholders personally liable under certain circumstances. Essentially, the creditor attempting to pierce the corporate veil will have to prove that the company is really just a shell or a sham, or that the corporation's actions were fraudulent, or that particular owners acted irresponsibly. Failing to follow corporate formalities is one of the most common reasons that creditors can pierce the corporate veil. For example, corporations have an obligation to conduct annual shareholders and board of directors meetings and keep minutes of these meetings. They must also issue stock and track the sale of stock. They also have reporting obligations to the state that must be met to keep their corporate status. Failing to fulfill any of these obligations may result in a claim that the corporation is not acting like a corporation and should be ignored to determine liability. Another common pitfall is that the owners or shareholders of the company do not maintain the business separately from their own personal responsibilities. This is particularly prevalent with single-owner entities. Companies need to have a separate bank account and financial tracking system. Failing to adhere to corporate requirements can ultimately undermine the asset protection that the corporation or LLC provides to its owners. Charging order protection. While many people have heard of corporate veil protection, charging order protection is far less well known. Charging order protection essentially offers asset protection in the opposite direction as corporate veil protection. It protects the business from legal obligations that may be created by the individual owners. For example, imagine that your daughter has friends over to jump on the trampoline. One friend falls off and is seriously injured. Her parents sue you, and your homeowner's insurance does not offer protection for trampoline accidents. That means that you must pay for the medical expenses associated with the fall on your own. If the girl's parents get a judgment against you, they can start trying to collect through putting a lien on your home or garnishing your wages. For business owners, this can be a problem because they may try to access some of the company's assets as part of their collection efforts as well. Charging order protection cuts off the liability with the business. Only you will be personally liable for the little girl's injuries. That way, your company will continue to function and be completely unaffected by your personal obligations. Charging order protection is particularly important for businesses that have many owners or in situations where the owners may be litigation-prone or own other businesses. In those circumstances, charging order protection helps other owners protect their investment as well. It simply would not be fair that one owner's personal liabilities would affect all of the owners. If a creditor does get a judgment against you and tries to collect, the only thing that he or she will be able to obtain from your business is the income that you receive from it. That is, if the company gives you wages or dividends, then the creditor may be able to garnish that income. Nonetheless, the assets and income provided to other owners will remain protected thanks to charging order protection. The limits of charging order protection. Just like corporate veil protection, charging order protection will only help you if your business is not a sham company or alter ego or extension of the owner. It may also be limited depending on the type of business entity you use. Generally, corporations offer strong charging order protection, but LLCs may not be as solid. One of the reasons that charging order protection developed is because of the fairness of it. That is, other owners of a company should not be liable for your personal debt obligations merely because they own a business with you. By shielding the business, charging order protection also protects the other owners of the company. However, when there is only one owner or member of an LLC, this rationale simply does not apply. Today, only 5 states provide charging order protection to single-member LLCs. Alaska, South Dakota, Nevada, Delaware, Wyoming. In fact, Delaware, Nevada, and Wyoming are often considered 3 of the friendliest states for business in the United States. The remaining 45 states limit charging order protection to multi-member LLCs and corporations. This fact is extremely important to keep in mind if you are considering forming a new business. Other means of asset protection planning. Developing a corporation or LLC is certainly not the only way that you can engage in asset protection planning. However, forming a business is the only means of obtaining corporate veil protection or charging order protection. Nonetheless, other asset protection tools may be used in combination with your company or separately. Examples of other asset protection tools may include the following. Insurance. Many people overlook insurance as an asset protection tool, but it can be useful in protecting you from creditors. Insurance can cover both personal liabilities and business obligations, making it a reliable choice for asset protection. General liability insurance, homeowners insurance, and auto insurance are all good examples of insurance that provide a valuable asset protection service on your behalf. Trusts. Trusts are similar to corporations or LLCs because they are also considered separate legal entities. However, the trust must be irrevocable to obtain this status. Otherwise, revocable trusts are often just regarded as an extension of the trust owner. In an irrevocable trust, the assets are transferred to the trust. As the owner of the trust is no longer the owner of the property within the trust, creditors have a much harder time accessing anything in the trust. Like businesses, however, creditors can still often obtain any income derived from the trust, including most distributions. Exempt assets. Most states have a list of exempt assets. These assets are those that creditors cannot legally take. They often include things like your home, your retirement account, or your personal items, clothing, home furnishings, etc. Putting money into these exempt assets allows you to keep the money safe from creditors. For example, some states completely exempt retirement accounts from creditor collection. By putting extra money in your retirement account, you are essentially keeping that money in a safe that creditors cannot touch. However, once you take the money out, a creditor may be able to reach it. The example also does not work if your state does not exempt retirement accounts. Many people also put additional money on their mortgage as an asset protection mechanism. This is because many states have a homestead exemption that protects your home from creditors. Gifts. If you no longer own the property, creditors generally have a hard time collecting it. That means that if you give gifts to others, creditors cannot go after that property either. However, it is important to note that gifting assets to others just before going to trial or filing for bankruptcy can be considered fraud. Be careful. Planning properly for asset protection. Asset protection planning requires careful thought and deliberation. It may also require some creativity. Regardless of how you decide to protect your assets, you need to get the process started early for it to be most effective when you need it. How to start a business. When you want more. Starting a business isn't nearly as complicated as most online guides make you think. Most websites talking about how to start a business just regurgitate old ideas. Starting a business used to involve a brick-and-mortar storefront, getting a bank loan, and taking on massive risk and debt. Times have changed. Now, starting a business is about getting started fast, often online. Making sales as soon as possible. Protecting yourself from liability. Protecting your privacy. We take you through the steps you need to get up and running and start doing business the right way. Below, we go over everything from making a plan to selecting the right business structure for your company and your state. Creating a business plan. Most websites and guides overcomplicate business plans. Down the road, sure, you'll want a fancy, formal business plan to show to potential lenders or investors. But you won't get lenders or investors without sales. And you won't get sales until you get started. What you need right away is to answer a few basic questions. What am I selling? Who is buying? How do I connect to buyers? What are my costs? How much do I charge? On our Small Business Ideas page, we've answered these questions for you for different types of businesses. Want to start a home-based graphic design business? How about a cleaning service? We've done the legwork for you in our ever-growing list of industry-specific guides. Learn which tools you'll need, steps you should take, and even how much to charge in our free guides. On this page, you can also find articles on popular business models, such as opening a franchise or selling products online. In addition, we tackle logistical questions you might encounter at every stage of your business, from choosing a business name to hiring employees. Choose a business structure after figuring out what your business is going to do and how it will make money, it's time to decide what kind of business structure is best for your business. Do you want to start an LLC? A sole proprietorship? A corporation? The structure you choose will play a major role in how your business is taxed, managed, and owned. It will also determine how much personal liability you have. Each business structure has different benefits and drawbacks. They also require different processes to get started. Below, we go over the most popular choices for business structures. Ready to explore a particular option? Sole proprietorships and partnerships. Have you made your first sale? Congratulations, you have a sole proprietorship or partnership. Unless you form an entity like an LLC or corporation, your default business is a sole proprietorship, one owner, or a partnership, multiple owners. And your business? It's an extension of yourself. It's not a separate legal entity. So all your company's liabilities are yours personally. On one hand, sole proprietorships and partnerships are simple. They don't require state paperwork to formally open or close. They're cheap unless you get sued or go bankrupt. There are no state filing fees or annual report fees. On the other hand, there are major downsides. No liability protection for yourself or your investors. No tax flexibility. No stocks. No prestige. No cool name without a DBA. Because of these downsides, once you've proven your concept and made some sales, it's time to protect yourself and your investors with an actual business entity, such as an LLC or corporation. Why form an LLC or corporation? With an LLC or corporation, you take on considerably less risk and have better control over how taxes affect your earnings. LLCs and corporations are business entities formed by filing articles with a state agency, typically the Secretary of State. Because these entities are subject to state filing fees and reporting requirements, they cost more to start and maintain. However, in exchange for extra fees and paperwork, you receive some significant advantages and protections, namely limited liability and tax flexibility. Limited liability. Both LLCs and corporations are legally separate entities from their owners. In other words, owners and investors are not personally liable for the debts and obligations of the business. Not only does this help protect your personal finances, but it also provides a much safer and more attractive scenario for investors. Tax flexibility. Unlike default business structures, LLCs and corporations have multiple tax election options. For instance, both can be taxed as C Corp or S Corp. Even if tax talk bores you to tears, it's easy to understand that having more options is more advantageous. You can pick the option that will save your business the most money or allow for the greatest opportunities. What about privacy? Many owners have concerns about maintaining their personal privacy when starting a business, and rightly so. Sole proprietors and general partners literally share their personal names with their businesses. LLCs and corporations require public state filings. But, with an LLC or corporation, there is an easy step you can take to better protect your privacy: hiring the right registered agent service. LLC versus corporation. So how are LLCs and corporations different? Mostly in ownership, management, and taxation. LLCs are owned by members and can be run by the members themselves, like a partnership, or by managers, like a corporation. LLCs also have the greatest number of tax election options. LLCs are initially taxed as disregarded entities or partnerships but can apply to be taxed as a C Corp or S Corp. In a standard corporation, shareholders own pieces of the corporation, represented by shares of stock. Stock is easily transferable, making investing in a corporation fairly simple. Shareholders elect a board of directors to make business decisions, including appointing officers. Corporations are automatically taxed as C Corp but can apply to be taxed as S Corp. Many non-profit corporations can qualify for tax-exempt status as well. Alter ego doctrine. In business law, the alter ego doctrine is often used as justification for piercing the corporate veil and assigning personal liability upon a business owner. This happens when a judge finds that there is not sufficient separation between the owner and the business entity. In these cases, the company is not its own entity but merely the alter ego of the owner. Separate entities and limited liability. Both a corporation and a limited liability company, LLC, are separate entities from their owners. In the eyes of the law, they are treated as distinct from their owners, able to enter into contracts, own assets, conduct business, sue and be sued, etc. Recent Supreme Court cases have even asserted that corporations have freedom of speech rights, just as a person does. When a lawsuit is brought against a corporation or LLC, the company's owners are protected from personal liability. They are shielded, in legal terms, by the corporate veil, which stands between themselves and the entity they control. This protection is known as limited liability. It is what stops a business owner from losing their home and other personal assets in order to satisfy a lawsuit. For example, say you purchase shares of stock in Microsoft. Good for you. You are now a partial owner of the company. If Microsoft is sued and found guilty for wrongdoing, however, a judge cannot order that you, a shareholder, must pay for the legal damages. You are protected by limited liability. Disregarding the corporation fiction, clearly a corporation or LLC is not a living, breathing thing. Thus, the idea of it being wholly separate from its owners and operators is a fiction. As well, the concept of a corporate veil between owners and their entity is but a novel metaphor. Though it serves many functions, this corporate fiction may be disregarded in a court of law under certain circumstances. When this happens, the court acknowledges that there is no discernible difference between the entity and its owner. Acknowledging that there is no separation between an owner and their entity does not, however, make the owner automatically liable. In order to assign personal liability, courts look for evidence of other wrongdoing. In most cases, courts have invoked the following 4 reasons for piercing the corporate veil: fraud, inadequate capitalization, intermingling of business and finances of the company and the owner, alter ego. In nearly every case, inadequate capitalization alone is not enough to justify piercing the corporate veil. However, when coupled with other reasons, especially fraud, courts have often pierced the veil. Determining the alter ego for a corporation or LLC to be ruled merely an alter ego of its owner, courts look at a variety of factors. It should be noted that an entity can be the alter ego of another entity, in cases in which Company A owns and operated Company B. All of the following factors have been used to determine if the charge of alter ego applies: gross undercapitalization, failure to observe corporate formalities, non-payment of dividends, intermingling of personal and business funds, treatment by an individual of assets as if they were their own, siphoning of corporate funds by dominant corporation or shareholder, non-functioning officers and directors, absence of corporate records, corporation merely a facade for the dominate corporation or shareholder. Case study: Keffer v. H.K. Porter Company, Incorporated. In 1989, the U.S. Court of Appeals ruled against H.K. Porter Company, Inc. and pierced the corporate veil, acknowledging that there was no substantial distinction between H.K. Porter Company, Porter, and its subsidiary, Connors Steel Company, Connors. In 1950, Porter purchased Connors and incorporated the company as a wholly owned subsidiary in 1974. Connors retirees were offered health and life insurance benefits as part of a collective bargaining agreement. The agreement was renegotiated every 3 years. An economic downturn caused Porter to close factories in 1982 and 1983. Retirees were informed that their benefits would terminate in 1984. The retirees sued, claiming their agreement guaranteed benefits until they were eligible for Medicare. Because Connors was bankrupt and could not pay its obligations, the retirees argued that there was no distinction between Connors and its parent company, Porter. Thus, according to the retirees, Porter was liable for paying the benefits. In deciding to pierce the corporate veil, the Court of Appeals noted the following: Connors was at all relevant times acting as Porter's agent, alter ego, and mere instrumentality. Porter's sale of the insolvent assets of Connors and retention of $9 million in proceeds. Porter's management and control system, which required Connors to get approval for all proposals and for any expenditure above $25,000. Making their ruling, the court stated it would be fundamentally unfair for Porter to hide behind the separate existence of Connors in order to avoid liability. Starting a business in your state. Every state has some major pros and cons when it comes to forming a business. Click any state name below to learn more about doing business the right way in your state. State pros cons. Alabama, cheap labor-only state where forming a business is a two-step process. Alaska, no personal income tax, makes you disclose ownership of companies as public information. Arizona, LLCs don't have annual reports. New LLCs have to publish in newspapers. Arkansas, low income tax rates, high franchise tax report. California, lots of potential customers, $800 minimum franchise tax payment. Colorado, online filings, processed instantly, annoying annual report system. Connecticut, everything is expensive and redundant. Delaware, famous for being home of many big holding corporations, high taxes for businesses actually operating in Delaware. District of Columbia, lots of potential clients needing services dealing with the DLCP and business licensing departments. Florida, no personal income tax, just don't miss your annual report filing, it'll cost you. Georgia, inexpensive fees, pointless newspaper publication requirements. Hawaii, laid-back attitude, easygoing lifestyle, high gross receipts tax. Idaho, no fee for annual reports, finding highly skilled and motivated employees. Illinois, Chicago rocks. High taxes, high fees, stifling regulations. Indiana, reasonable fees, reasonable taxes, none. Iowa, biennial reports, low costs. Unfortunately, there's just not a lot of business in Iowa. Kansas, the SOS is fast and helpful. Costs are fairly high compared to the rest of America. Kentucky, cheap place to initially start a business, redundancy, filing at the state level and then the county level. Louisiana, friendly, helpful people, redundant, complicated procedures. Maine, reasonable fees, weird/confusing lingo about clerks and commercial registered agents. Maryland, less regulatory than DC, it takes 2 months to process filings. Massachusetts, they're actually good with their expedited filings, their nickname is Taxachusetts. Michigan, taxes are pretty low and office space is super cheap now unless you happen to be an automaker. Minnesota does not charge domestic businesses an annual report fee, slow to process your filings. Mississippi, not a highly regulated state, horrible filing fees for foreign corporations. Missouri, an inexpensive and reasonable place to do business. The initial report after your initial filing is purely redundant. Montana, inexpensive, quick filings, none. Nebraska, low startup costs, they require original inked signatures, so 1980s. Nevada, great asset protection rules, it's become very expensive and over-regulated. New Hampshire, no sales tax, original signatures required, slow to process filings. New Jersey, well, at least it isn't New York, minimum $500 tax, plus prepay 1/2 for the next year. New Mexico, great laws for LLCs, their foreign corporation annual reports are awful. New York, there really aren't any. It's the second worst state to do business in. North Carolina, they deny some filings for weird reasons. North Dakota, lots of opportunity these days, their infrastructure has yet to catch up. Ohio, no annual reports, the Department of Revenue is confusing. Oklahoma, a reasonable and cheap place to do business, some confusing regulations, filings, and procedures. Oregon, no sales tax, high income taxes. Pennsylvania, no annual reports, lots of high fees and paperwork. Rhode Island, really, there aren't any high fees, high taxes, minimum tax payments. South Carolina, low taxes, no annual reports, they're kind of slow and require original signatures. South Dakota, no personal income tax, very aggressive Department of Revenue. Tennessee, high filing fees and taxes. Texas, great for small businesses, the SOS charges $1 for name searches. Utah, 5% income tax, $70 to start your business, they send everything to your registered agent. Vermont, low-cost registrations and annual fees, original signatures requires confusing forms. Virginia, it's a little better than DC, high taxes and fees for big corporations. Washington, no personal income tax, overregulated and going broke. West Virginia, easy and reasonable state to do business in, none. Wisconsin, none, high fees, weird procedures, and the foreign corp annual report is laughable. Wyoming, low taxes, fees and great asset protection laws, they require original signatures. How to start a business in Alaska. How do you start a business in Alaska? The short answer, sell something. Bang, you're a sole proprietor in Alaska, the only state in the country with both no personal income tax and no sales tax. But some better questions may be these: how can you make money with your business? What should you do to protect that money? And what legal requirements do you need to meet? In this beast of a guide, we'll show you. 1. Pick a business structure. If you're out there hawking t-shirts or tutoring services on your own, and you haven't registered with the state, you're a sole proprietor. If you're doing it with partners, you're operating a general partnership. In either scenario, you have no liability protection. This means that the business debt is your debt. If someone sues your business, they sue you. Your personal assets, like your car, house, and the money in your personal checking account, are potentially all fair game. If you want liability protection, you have to form a separate entity. An entity is just a thing with its own independent existence, and in the case of a business entity, its own liability. The two most common entity types with limited liability are LLCs and corporations. Alaska Limited Liability Company, LLC. LLCs are flexible business structures. You can hire a manager or managers to run the LLC, or do it yourself. You also have more tax classification options than other entities. For their adaptability and strong liability protection, LLCs are a popular choice among small businesses. To start an Alaska LLC, you'll need to file paperwork with the Division of Corporations. Alaska corporations are less flexible than LLCs. They have to follow strict record-keeping rules and adhere to a rigid management structure. Shareholders appoint a board, and the board elects officers to run the corporation. Investors and donors often view corporations as more accountable than other entity types, thanks to these rules. To form an Alaska corporation, you'll need to file paperwork with the Division of Corporations. Can an LLC be just one person? Yes. A one-person LLC is called a single-member LLC. Single-member LLCs are one of the most common kinds of businesses in the country. For the most part, single-member LLCs are just like multi-member LLCs, but there are some slight differences in how they file taxes and protect personal assets. What about an Alaska nonprofit? 2. Name your business. Naming a business in Alaska isn't as straightforward as it may seem. Without a separate entity like an LLC or corporation, you're stuck using your own first and last name for your business, Jamie Garcia, or getting a DBA for something more descriptive, like Jamie's Organic Ice Cream. For an LLC or corporation, you'll need a business name that will meet Alaska's requirements. It must use an appropriate identifier, like LLC for a limited liability company or Inc. for a corporation. Not use words that describe government agencies like police or Department of State. Not use words that suggest a false business purpose, like charity or nonprofit, unless your business is a nonprofit. Not use words that describe a service that requires a professional license, like architect or doctor. Be unique in the state of Alaska. Find out if your desired name is available in Alaska by searching the Alaska Corporations database. Can I reserve a business name in Alaska? Yes. If you have a business name in mind but you're not ready to file paperwork to form your business, you can reserve it in Alaska for up to 120 days by filing a certificate of reservation. But beware, reserving a business name in Alaska adds an extra step to forming your business. That's because before you can form an LLC or corporation, you'll have to get in touch with the Division of Corporations to cancel your name reservation. Usually they'll cancel your name reservation in 1 to 2 days. What's a DBA? What about trademarked names? 3. File formation paperwork. If you're a sole proprietor or part of a general partnership, you don't need to file formation paperwork with the Division of Corporations because you're not creating a separate business entity. You do, however, need to get an Alaska business license. But to start an Alaska LLC or corporation, you'll need to file paperwork with the Alaska Division of Corporations. This is the step that officially brings your business entity into existence. To form an Alaska LLC, file Alaska Articles of Organization. To start an Alaska corporation, file Alaska Articles of Incorporation. To fill out these forms, you'll need to list an Alaska registered agent to handle your legal mail. Once you've completed the form, you'll need to send it to the Alaska Division of Corporations. You can submit it online, by mail, or in person. Note, the information you list on this form will become part of the public record. This means that the names and addresses you provide will be posted online on the Alaska Corporations database for anyone to find. What is a registered agent? A registered agent is the person or entity responsible for receiving legal mail on behalf of your business. Your registered agent must have a physical address in Alaska where they're present during business hours to accept service of process. Of course, not all business owners do the kind of work that allows them to be present at a physical address all day. You can't exactly accept service of process from a saner. For this reason, many businesses opt to hire a registered agent to serve as their business's point of contact. How can I keep my information off the public record? 4. File an Alaska Initial Report. Alaska requires LLCs and corporations to file an initial report within their first 6 months. This filing just requires providing a little more information about your business, including the names and addresses of your members/managers or directors/officers. It's free to file and you can do it online. Since you have to file the initial report within your first 6 months, we recommend just doing it when you file your formation paperwork. When we form your LLC or incorporate for you, we file your initial report at the same time. After your initial report, you'll have to file a biennial report every year by January 2nd. If you started your business in an even-numbered year, you'll always file your biennial report in an even-numbered year. What if I don't file a biennial report in Alaska? In Alaska, there's a 1-month grace period before the state hits you with late fees. And if you continue to fail to file, the Alaska Division of Corporations could involuntarily dissolve your business. To reinstate, you'd have to pay double the filing fee for each missed report. 5. Draft internal records. So far in this guide, we've dealt with public forms that you've had to file with the Alaska Division of Corporations. Now, it's time to organize your internal records. These are the documents your business will keep on record within your company. Though these documents are internal, you'll likely need to show them to third parties like the bank or, if you start a nonprofit, the IRS. Here are the major documents you'll need. Alaska LLC Operating Agreement. This is your LLC's rulebook. It defines how your LLC will do things like make decisions, distribute money, manage operations, and appoint officers. Your operating agreement plans for every big picture scenario your LLC is likely or unlikely to face, including dissolution. Drafting an operating agreement is hard, and the internet is full of shabby templates that have been copy and pasted from who knows where. Alaska Corporate Bylaws. Bylaws are the rules your corporation will adopt and follow internally. Bylaws detail how your corporation will appoint directors and officers, hold shareholder and board meetings, and handle emergencies, among other things. Unlike operating agreements, corporate bylaws are required by law in Alaska. See AK Stat Section 10.06.223. 6. Get Alaska business licenses. All businesses in Alaska need a business license, even sole proprietors. Some businesses will need additional licenses. Alaska state business license. Aside from a handful of exceptions, every business in Alaska needs a state business license. Those that don't owe fisheries, insurance companies, mines, and anyone selling liquor need a more specialized license from the department regulating their industry. And if you register any DBAs, you'll need a separate license for each one. Professional Alaska business licenses. Professional services are ones that require specialized training or education to perform safely. Think architecture, midwifery, counseling, construction, or dentistry, just to name a few. See the Alaska Professional Licensing section of the Division of Corporations for a full list. To get a professional license, you have to apply with the board that regulates your industry in Alaska. Each board has its own licensing process. Local Alaska business licenses. Depending on what kind of business you're doing and where you're doing it, you might need a city or a borough business license. In Haynesboro, for example, all businesses need a city license in addition to the Alaska state business license. In Anchorage, only some businesses do, like private investigators or pawnbrokers. How do I get an Alaska business license? You just have to do more paperwork. You'll fill out an application that requests basic information about your business, like its name, entity type, and address. You can submit the Alaska business license application online or by mail. How much does it cost to get an Alaska state business license? How do I get a professional license in Alaska? How do I get a local business license? 7. Organize your money. The liability protection you get from forming an LLC or corporation is only as strong as the separation between you and your business. At a minimum, you'll need to open a bank account for your business. And if you're going to hire employees, you'll need to tackle payroll, too. Open a business bank account to keep your business spending separate from your personal spending. You'll need to open a business bank account. If you don't, a court could find that your business is not actually separate from you, the owner, under the alter ego doctrine. Also known as piercing the corporate veil, this is the outcome when a judge finds that a company is not a separate entity but rather an alter ego of the owner. If this ever happens, you could lose your limited liability status. Opening a business bank account as a sole proprietor is important, too. Though sole proprietors and general partnerships have no limited liability status to protect, both will benefit from organizing their business finances come tax season. How do you set up a business bank account? LLCs and corporations will need to provide the bank with their formation documents, operating agreement or corporate bylaws, EIN, and in some cases, a corporate resolution to open a bank account or LLC resolution to open a bank account. Do I need a business bank account to accept credit card payments? Set up payroll. If you're planning to hire employees or independent contractors, you need to set up payroll. To do so, you'll need to get an EIN, register for an Alaska employer account number, find your employer unemployment insurance, UI, contribution rate, determine whether you're hiring employees or independent contractors, prepare the forms your employees will fill out, choose a payroll service or software, decide on a payroll schedule. Setting up payroll in Alaska is complicated, but a solid payroll service or software will automatically withhold payroll taxes, file state and federal returns on your behalf, and pay your Employees either by check or direct deposit, whichever you choose. What forms do my employees need to fill out? Your new employees will need to fill out a W-4 to determine how much you'll withhold and an I-9 to verify that the employee is eligible to work in the U.S. What's the difference between an independent contractor and an employee? How do I get an Alaska employer account number? 8. Get business insurance. Forming an LLC or corporation protects your personal assets. But if anything disastrous befalls your business, like a lawsuit, burglary, flood, or fire, your business is on the hook to pay. Business insurance can help cover the costs. But do you really need business insurance? Maybe, maybe not. Certain coverage is required by law in Alaska, but whether or not you should purchase additional insurance depends on the level of risk you're comfortable taking on. Here's a breakdown of the most commonly purchased business insurance. Workers' compensation insurance. If you have one or more employees, this one is required by law in Alaska. Unlike most states, Alaska has no state fund to compensate workers who are injured on the job for lost wages or medical bills. If you don't purchase workers' compensation insurance, the consequences are pretty grim. Your business could be ordered to stop immediately and could eventually face fines of up to $1,000 per day. You can buy a workers' compensation insurance plan through an insurance company. Liability insurance. This covers the costs of claims against your business for injuries or damages to the property of others, like clients or customers. This includes medical expenses, legal fees, settlements, and judgments. Whether or not you need it depends on whether your business is likely to be sued and how many assets your business needs to protect. If it's just you and your computer in your basement, you might feel comfortable skipping liability insurance. Or maybe you won't. Beyond general liability insurance, you can purchase or add on more specific types, like professional, cyber, commercial, home-based business, or product liability insurance. Do business owners need workers' compensation insurance in Alaska? Workers' compensation insurance is only required by law in Alaska for employees. Corporate officers and LLC members who own at least 10% of their business aren't considered employees in Alaska and don't need to be covered. However, your health insurance plan could deny a claim for a business-related injury, so it's not a bad idea to include yourself on your business workers' compensation insurance plan. Do I need business insurance for my home-based business? 9. Understand your tax burden. Alaska is the only state in the country with no personal income tax and no sales tax. Corporate tax rates in Alaska are fairly low, and the state even pays out an annual dividend to all residents who have lived in the state for over a year. But your tax burden isn't determined by the state alone. You'll also have federal and local taxes to consider. Federal taxes. LLCs, single-member LLC. By default, you're taxed similar to a sole proprietor. More than one LLC owner? You're taxed as a general partnership. Either way, your default tax status is pass-through, which means you don't pay corporate taxes. Instead, your LLC's owners report profits and losses on their personal tax returns. Good news, because there's no state income tax in Alaska, you'll only have to pay the 15.3% federal self-employment tax rate. An LLC can file paperwork with the IRS to be taxed as an S-corp or C-corp instead. Corporations. Corporations are taxed as C-corp by default. This means that corporations pay the 21% federal corporate tax rate and the applicable Alaska corporate tax rate. To pay your federal taxes, and take a good deal of other steps required to start a business, you'll need to get an Employer Identification Number, EIN. You can apply for one with the IRS or hire us to get one for you. Do I need an EIN if I'm self-employed? If you're operating a sole proprietorship or single-member LLC that doesn't employ anyone else and you don't need to file excise or pension plan returns, you don't legally need an EIN. However, you can still get one, and you probably should. Otherwise, you'll have to use your own social security number to do business. Plus, you'll likely need an EIN to open a business bank account. How to start a business in South Dakota. How do you start a business in South Dakota? The quick answer: by selling services or products. Then, you'll be a sole proprietor in South Dakota. And, with no corporate, individual, business inventory, or personal property taxes, you'll be able to retain more of your hard-earned money. Ka-ching. But what about asset protection? After all, you need to protect your money. We're here to make sure you understand everything you need to know about operating a business in South Dakota. 1. Pick an entity type. Sole proprietorships are the easiest business entity to start in South Dakota. After sole proprietorships, general partnerships are the second easiest to form and could be considered similar to sole proprietorships, except they are formed with 2 or more people. Unfortunately, a sole proprietorship or general partnership don't provide you with liability protection. Without liability protection, there is no distinction between you and your business. And without a distinction, you will be held responsible for all business-related debts and legal issues. If you want liability protection, you'll want to form either a limited liability company or a corporation. South Dakota Limited Liability Company, LLC, a simple business entity that still offers liability protection, is a limited liability company or LLC. They have a flexible management structure and can choose to maintain their default tax status or be taxed as a corporation. Unlike corporations, which we'll cover next, LLCs aren't held to as many state regulations and close oversight. To start a South Dakota LLC, you'll need to file paperwork with the Secretary of State. South Dakota corporations are the most complex business entity you can form. Since South Dakota recognizes corporations as individual entities, corporations must appoint a board of directors and offer stock. To form a South Dakota corporation, you'll need to file paperwork with the South Dakota Secretary of State. Can an LLC be just one person? Yes. A one-person LLC is called a single-member LLC. Single-member LLCs are one of the most common kinds of businesses in the country. For the most part, single-member LLCs are just like multi-member LLCs, but there are some slight differences in how they file taxes and protect personal assets. What about a South Dakota nonprofit? 2. Name your business. Naming a business in South Dakota requires following specific statutes for your entity. However, as a sole proprietor or general partnership, your business name will be your human name, unless you get a DBA. For LLCs and corporations, you'll need a business name that meets South Dakota's requirements. Your business's name must use an appropriate identifier, like LLC, L.L.C. for a limited liability company, or Inc., Incorporated for a corporation. Be unique in the state of South Dakota. Find out if your desired name is available in South Dakota by searching the South Dakota Business Name Availability Database. Can I reserve a business name in South Dakota? Yes. You can file forms with the Secretary of State to reserve your business name for 120 days if you're waiting to form your business. Life happens. We get that starting a business takes time from creation to formation. And so does South Dakota. If you are reserving a name for a limited liability company in South Dakota, you'll need to file the application for reservation of name Limited Liability Company, $25. If you're reserving a name for a corporation, excluding nonprofits, you'll need to file the application for reservation of name Business Corporation, $25. What is a DBA? What about trademarked names? 3. File formation paperwork. To form a South Dakota LLC or corporation, you'll need to file paperwork with the South Dakota Secretary of State. To form a South Dakota LLC, file South Dakota Articles of Organization. To start a South Dakota corporation, file South Dakota Articles of Incorporation. You'll need to list a South Dakota registered agent on these forms who will handle your legal mail. Note: This information is all available through the South Dakota Business Information Search. Anyone with your business's name can look up your home address, name, and any other personal information you list. What is a registered agent? A registered agent is a person or entity responsible for accepting legal mail for your business. Your registered agent is required to have a physical address in South Dakota, where they are present during regular business hours to accept your legal mail. The problem many business owners face is that their business often takes them away from their regular address. Having a registered agent like MyNewNetworth.org allows you the freedom to run your business knowing you don't have to be tied to one location waiting to accept mail. How can I keep my information off the public record? 4. Draft internal records. So far in this guide, we've dealt with public forms that you've had to file with the South Dakota Division of Corporations. Now, it's time to organize your internal records. These are the documents your business will keep on record within your company. Though these documents are internal, you'll likely need to show them to third parties like the bank or, if you start a nonprofit, the IRS. Here are the major internal documents you need to organize for LLCs and corporations. South Dakota LLC Operating Agreement. This is your LLC's rulebook. It defines how your LLC will do things like make decisions, distribute money, manage operations, and appoint officers. Your operating agreement plans for every big picture scenario your LLC is likely or unlikely to face, including dissolution. Drafting an operating agreement is hard, and the internet is full of shabby templates that have been copy and pasted from who knows where. So we had our attorneys draft a South Dakota LLC operating agreement template that you can use as a solid foundation. South Dakota corporate bylaws. Bylaws are the rules your corporation will adopt and follow internally. Bylaws detail how your corporation will appoint directors and officers, hold shareholder and board meetings, and handle emergencies, among other things. Unlike operating agreements, corporate bylaws are required by law in South Dakota. See SD Codified L Section 47-1A-206. As with operating agreements, you can find plenty of bylaw templates online. But bylaws are pretty serious, so you don't want to just use the first template you come across. 5. Get South Dakota business licenses. Before you can start doing business legally in South Dakota, you'll likely need to get a business license. In South Dakota, the Department of Revenue requires any business with a physical presence in South Dakota, including sole proprietors, to have a license to collect sales tax. Some businesses will need additional licenses. To help you sort out what you'll need, we go over a few common licenses required in South Dakota below. South Dakota State Tax License. The South Dakota Department of Revenue states any business conducting transactions related to the sale of personal property, products transferred electronically, or services must be licensed to collect sales tax. If your business doesn't have a physical address in South Dakota, you don't need a license. Unless your business's gross revenue from South Dakota goes over $100,000 or you've made over 200 separate deliveries into South Dakota. Professional business licenses. Are you a licensed nurse or social worker in South Dakota, looking to start your business? Then, you, along other professions that require special education or training, will need to get additional South Dakota licensing through the South Dakota Department of Labor and Regulation and with the Department of Social Services and the Department of Health. Check out the South Dakota Department of Labor and Regulation for the list of all professional licenses and the filings needed. Local business licenses. Regardless of where your business is located, you'll still need to check your local jurisdiction's licensing requirements. For example, in Sioux Falls, South Dakota, auctioneers are required to obtain an auction sale of jewelry license. And in Aberdeen, South Dakota, home daycare providers must get licensed from the city. So, you'll want to make sure you're compliant with your city or county. How do I get a South Dakota tax license? You'll apply for your tax license using the South Dakota Online Tax Licensing application. In addition to basic information about your business, You'll also need to provide your EIN or SSN, DBA, if applicable, and your business's primary mailing address. How much does it cost to get a South Dakota state tax license? How do I get a professional license in South Dakota? How do I get a local business license? 6. Organize your money. The liability protection you get from forming an LLC or corporation is only as strong as the separation between you and your business. At a minimum, you'll need to open a bank account for your business. And if you're going to hire employees, you'll need to tackle payroll too. Open a business bank account to keep your business spending separate from your personal spending. You'll need to open a business bank account. If you don't, a court could find that your business is not actually separate from you, the owner, under the alter ego doctrine. Also known as piercing the corporate veil, this is the outcome when a judge finds that a company is not a separate entity but rather an alter ego of the owner. If this ever happens, you could lose your limited liability status. Opening a business bank account as a sole proprietor is important, too. Though sole proprietors and general partnerships have no limited liability status to protect, both will benefit from organizing their business finances come tax season. How do I set up a business bank account? If you've formed an LLC or corporation, you will need to provide the bank with your formation documents, operating agreement or corporate bylaws, EIN, and in some cases, a corporate resolution to open a bank account or LLC resolution to open a bank account. Do I need a business bank account to accept credit card payments? Set up payroll. One of South Dakota's biggest perks for small business owners like yourself is their lack of income tax. No income tax means less forms and calculations for you if you decide to hire employees or independent contractors. To do so, you'll need to get an EIN register for a South Dakota Reemployment Assistance Tax Account Number register with the South Dakota Department of Labor and Regulation. Determine whether you're hiring employees or independent contractors. Prepare the forms your employees will fill out. Choose a payroll service or software. Decide on a payroll schedule. Setting up payroll in South Dakota doesn't have to be complicated. To help you along the way, select a reliable and secure payroll service or software that will automatically withhold payroll taxes, file state and federal returns, and pay your employees either by check or direct deposit. What forms do my employees need to fill out? Your new employees will need to fill out a W-4 to determine how much you'll withhold and an I-9 to verify that the employee is eligible to work in the U.S. What's the difference between an independent contractor and an employee? How do I get a South Dakota Reemployment Assistance Tax Account Number? 7. Get business insurance. Forming an LLC or corporation protects your personal assets. But if anything disastrous befalls your business, like a lawsuit, burglary, flood, or fire, your business is on the hook to pay. Business insurance can help cover the costs. South Dakota does not require every business to have business insurance, but depending on what you'll be doing, you may want to make sure you and your business are insured. Here's what you need to know. Workers' compensation insurance. South Dakota doesn't have a law requiring employers to have workers' compensation insurance. However, you may want to get workers' insurance to avoid dealing with being sued by injured employees. Without the insurance, you're liable for any injuries sustained by your employees while performing their jobs. Liability insurance. This covers the costs of claims against your business for injuries or damages to the property of others, like clients or customers. This includes medical expenses, legal fees, settlements, and judgments. Whether or not you need it depends on whether your business is likely to be sued and how many assets your business needs to protect. If it's just you and your computer in your basement, you might feel comfortable skipping liability insurance. Or maybe you won't. Beyond general liability insurance, you can purchase or add on more specific types, like professional, cyber, commercial, home-based business, or product liability insurance. Do business owners need workers' compensation insurance in South Dakota? No. South Dakota does not require employers to purchase or have workers' compensation insurance. Though it is a great idea to get workers' insurance to avoid any mishaps. Do I need business insurance for my home-based business? 8. Understand your tax burden. South Dakota has no corporate, individual, business inventory, or personal property taxes. Having limited taxes to pay makes South Dakota a top state to form a business in. But your tax burden isn't determined by the state alone. You'll also have federal, state, and local taxes too. Consider federal taxes. LLCs, single-member LLC. By default, you're taxed similar to a sole proprietor. More than one LLC owner? You're taxed as a general partnership. Either way, your default tax status is pass-through, which means you don't pay corporate taxes. Instead, your LLC's owners report profits and losses on their personal tax returns. Good news, because there's no state income tax in South Dakota, you'll only have to pay the 15.3% federal self-employment tax rate. An LLC can file paperwork with the IRS to be taxed as an S-corp or C-corp instead. Corporations. Corporations are taxed as C-corp by default. This means that corporations pay the 21% federal corporate tax rate and no corporate tax in South Dakota. To pay your federal taxes, and take a good deal of other steps required to start a business, you'll need to get an Employer Identification Number, EIN. You can apply for one with the IRS or hire us to get one for you. Do I need an EIN if I'm self-employed? If you're operating a sole proprietorship or single-member LLC that doesn't employ anyone else and you don't need to file excise or pension plan returns, you don't legally need an EIN. However, you can still get one, and you probably should. Otherwise, you'll have to use your own Social Security number to do business. Plus, you'll likely need an EIN to open a business bank account. How do I get an EIN? What is an S-corp? What is a C-corp? Local South Dakota business taxes. While there may be low to no taxes on the corporate and high level, but there are still local taxes to take into account. South Dakota's local business taxes are municipal sales tax, up to 2%, use tax, and gross receipts tax, 1%. How to start a business in Nevada? How do you start a business in Nevada? You offer a product or service without filing formation paperwork. This automatically makes you a sole proprietor. Because Nevada doesn't have a corporate or personal income tax, many people chose to start a business in the Silver State. However, sole proprietors don't have asset protection. So, how do you protect your assets? How do you maintain your privacy as a business owner? We'll tell you all of this and more in our detailed guide. Ready to start a business in Nevada? 1. Pick a business structure. Sole proprietors and general partnerships don't need to file formation paperwork to exist. These businesses exist as soon as you offer a product or service. For example, selling your books on the street or being a freelance editor, without filing paperwork, makes you a sole proprietor. If you do business with a partner and haven't filed paperwork, you're a general partnership. Both entities make you a business owner, but neither entity provides you with asset protection. That's because you and the business are one and the same. If your business gets sued, your car, home, and savings could be at risk. LLCs and corporations are common business choices for people who want limited liability protection. If someone sues your LLC or corporation, only your business's assets might be seized. Nevada Limited Liability Company, LLC. LLCs are a popular business entity because they're so flexible. You can run an LLC by yourself, elect members, or hire an outside manager to run the company. LLCs are taxed as a pass-through entity by default, but they can elect to be taxed as an S or C corporation as well. To start a Nevada LLC, you must file paperwork with the Nevada Secretary of State. Nevada corporations are not as flexible as LLCs. Statutory law requires shareholders to appoint a board of directors, who are responsible for making big-picture decisions for the corporation. The board of directors then elect officers to manage the company's daily affairs. The strict rules corporations must follow, along with the ability to offer stock options, make them preferable to investors. To start a Nevada corporation, you'll need to file paperwork with the Nevada Secretary of State. Can an LLC be just one person? Yes. A one-person LLC is called a single-member LLC. Single-member LLCs are one of the most common kinds of businesses in the country. For the most part, single-member LLCs are just like multi-member LLCs, but there are some slight differences in how they file taxes and protect personal assets. What about a Nevada nonprofit? 2. Name your business. Naming your business is the next step to forming an LLC or corporation. If you're a sole proprietor or general partnership, your personal name will automatically be the business's name. However, if you're an LLC or corporation, you can choose your company's name as long as you meet certain naming guidelines. You must include a business identifier like Limited or LLC for a limited liability company and Inc. or Corp. for a corporation. You can't use misleading words that suggest your business offers services that it doesn't offer. You must get approval to use government-related words like police or bank from the appropriate institutions. Find out if your desired name is available in Nevada by searching the list of Nevada reserved names. Can I reserve a business name in Nevada? Absolutely. You can reserve a business name in Nevada by submitting the name, reservation, consent or release form along with the $25 application fee. You can reserve a business name for 90 days. What is a DBA? What about trademarked names? 3. File formation paperwork. Sole proprietors and general partnerships don't need to file formation paperwork with the state because those businesses are not legally separate from you. LLCs and corporations, on the other hand, must file formation paperwork with the Nevada Secretary of State. To form a Nevada limited liability company, file articles of organization. To start a Nevada corporation, file articles of incorporation. You'll need a Nevada registered agent before you submit either form. Note: the information you list on either form will become part of the public record. In other words, the names and addresses you provide will be posted online on Nevada's Secretary of State website for anyone to find. How can I keep my information off the public record? You can keep your information off the public record by hiring a registered agent, like MyNewNetworth.org, who will put their name and address on the public record instead of yours. What is a registered agent? 4. File a Nevada initial report. Nevada requires LLCs and corporations to file an initial list along with their formation paperwork and business license application. To fill out the initial list, you'll need to include the names of your officers, directors, or managers, as well as other information such as their address. It costs $150 to submit your initial list. After you file your initial report, you'll file an annual list every year with the Nevada Secretary of State, $150. Your report will be due by the end of your anniversary month. For example, if you formed your business on April 25, 2022, your annual list will be due by April 30, 2023. What if I don't file an initial or annual report in Nevada? If you fail to include an initial report with your articles of organization or articles of incorporation, the state will likely reject your paperwork. If you fail to file your annual report, you will be assessed a $75 penalty fee. 5. Draft internal records. So far in this guide, we've dealt with public forms that you've had to file with the Nevada Secretary of State. Now, it's time to organize your internal records. These are the documents your business will keep on record within your company. Though these documents are internal, you'll likely need to show them to third parties like the bank or, if you start a nonprofit, the IRS. Here are the major internal documents you need to organize for LLCs and corporations. Nevada LLC Operating Agreement. This is your LLC's rulebook. It defines how your LLC will do things like make decisions, distribute money, manage operations, and appoint officers. Your operating agreement plans for every big picture scenario your LLC is likely, or unlikely, to face, including dissolution. Drafting an operating agreement is hard, and the internet is full of shabby templates that have been copy and pasted from who knows where. Nevada corporate bylaws. Bylaws are the rules your corporation will adopt and follow internally. Bylaws detail how your corporation will appoint directors and officers, hold shareholder and board meetings, and handle emergencies, among other things. Nevada law doesn't mandate that you have bylaws, but it is highly recommended that you have them to ensure your corporation runs smoothly. As with operating agreements, you can find plenty of bylaws templates online. But bylaws are pretty serious, so you don't want to just use the first template you come across. 6. Get Nevada business licenses. LLCs and corporations must have a Nevada state business license to conduct business. However, you may also need additional licenses depending on where you operate and do business and whether or not you offer professional services. Nevada state business license. Most Nevada businesses, including sole proprietors and general partnerships, will need to obtain a Nevada state business license from the Secretary of State. However, some business, such as nonprofits, won't be required to get a state license. In this case, you would file a declaration of eligibility for state business license exemption. Professional business licenses. You'll need a professional business license to offer specialized services, such as cosmetology, engineering, or nursing home care. Boards will have their own requirements for becoming licensed. For example, to become a licensed attorney, you must pass the Nevada Bar Exam, take the Multi-State Professional Responsibility Exam, MPRE, and get sworn in by a judicial officer or notary public in any Nevada jurisdiction. However, if you want to become an accountant, you'll take the CPA and become certified by the Nevada State Board of Accountancy. Local business licenses. Depending on where you do business, you may need a local business license. In most cities, you'll only need a specific license based on the service or products you provide. For example, you'll need an independent massage therapist license to work as a masseuse in Las Vegas. However, 2 cities, Nevada City and Grass Valley, have a mandatory general business license. So, if you operate the same business in Nevada City or Grass Valley, you would need to obtain a general business license in addition to an independent massage therapist license. How do I get a Nevada business license? The Nevada State Business License is a part of your Articles of Incorporation and Articles of Organization applications, which you'll get via the Nevada Silver Flume website, so you won't have to go a separate site to apply for the state business license. After you complete the Nevada State Business License application, you can file it by mail, fax, in person, or online. You must renew your license every year. How much does it cost to get a Nevada state business license? How do I get a professional license in Nevada? How do I get a local business license? 7. Organize your money. The liability protection you get from forming an LLC or corporation is only as strong as the separation between you and your business. At a minimum, you'll need to open a bank account for your business. And if you're going to hire employees, you'll need to tackle payroll, too. Open a business bank account to keep your business spending separate from your personal spending. You'll need to open a business bank account. If you don't, a court could find that your business is not actually separate from you, the owner, under the alter ego doctrine. Also known as piercing the corporate veil, this is the outcome when a judge finds that a company is not a separate entity but rather an alter ego of the owner. If this ever happens, you could lose your limited liability status. Opening a business bank account as a sole proprietor is important, too. Though sole proprietors and general partnerships have no limited liability status to protect, both will benefit from organizing their business finances come tax season. How do you set up a business bank account? LLCs and corporations will need to provide the bank with their formation documents, operating agreement or corporate bylaws, EIN, and in some cases, a corporate resolution to open a bank account or LLC resolution to open a bank account. Do I need a business bank account to accept credit card payments? Set up payroll. A payroll schedule is necessary to pay your employees or independent contractors. To set up payroll, you'll need to get an EIN and enroll in Nevada's electronic federal tax payment system. Set up an unemployment insurance tax account in Nevada. Decide whether you'll have employees or independent contractors. Gather payroll documents from your employees or independent contractors. Decide a payroll schedule. File a quarterly NUCS 4072 form with Nevada's Department of Employment, Training, and Rehabilitation Contributions Office. You can keep track of payroll by hand, but this can make tracking things like PTO confusing. To avoid potential record-keeping problems, most businesses use an online or software program to manage their pay schedule. What forms do my employees need to fill out? Your new employees will need to fill out a W-4 to determine how much you'll withhold and an I-9 to verify that the employee is eligible to work in the U.S. What's the difference between an independent contractor and an employee? How do I get a Nevada employer account number? 8. Get business insurance. Forming an LLC or corporation protects your personal assets. But if anything disastrous befalls your business, like a lawsuit, burglary, flood, or fire, your business is on the hook to pay. Business insurance can help cover the costs. But, in most cases, whether or not you decide to get business insurance is up to you. Depending on whether or not you have employees or independent contractors and how many workers you have, you may be required to obtain some coverage for your company in Nevada. But adding additional coverage will depend on how much risk you're willing to take. Here are the most common types: business insurance. Workers' compensation insurance. There are some exceptions, but, generally, you must purchase workers' compensation insurance if you have at least one employee. Employees excluded from this rule include casual workers, interstate commerce employees, and temporary workers from another state where they're already insured. For a complete list of exempt employees, see NRS 616A.110. If you have an employee and don't buy this coverage, the state can fine you up to $15,000. You may even be ordered to shut down your business until you get workers' compensation insurance. But considering all the benefits that come with workers' compensation insurance, it's in your best interest to get coverage. Liability insurance. This covers the costs of claims against your business for injuries or damages to the property of others, like clients or customers. This includes medical expenses, legal fees, settlements, and judgments. Whether or not you need it depends on whether your business is likely to be sued and how many assets your business needs to protect. If it's just you and your computer in your basement, you might feel comfortable skipping liability insurance. Or maybe you won't. Beyond general liability insurance, you can purchase or add on more specific types, like professional, cyber, commercial, home-based business, or product liability insurance. Do business owners need workers' compensation insurance in Nevada? No. Nevada doesn't require business owners to cover themselves with workers' comp insurance. However, buying workers' compensation coverage for yourself has several advantages. For example, if you suffer a work injury, it is unlikely that your personal insurance will pay your medical bills. Do I need business insurance for my home-based business? 9. Understand your tax burden. Nevada is one of a few states that doesn't have a personal income tax or a corporate income tax. However, it does have a state sales tax, which is 6.85%. And, if your business earns $4 million or more a year, you're required to file a commerce tax. Thankfully, most businesses won't need to pay this tax. However, there are also federal and local taxes to consider. Federal taxes. LLCs. Single member LLC. by default, you're taxed similar to a sole proprietor. More than one LLC owner? You're taxed as a general partnership. Either way, your default tax status is pass-through, which means you don't pay corporate taxes. Instead, your LLC's owners report profits and losses on their personal tax returns. Good news, because there's no state income tax in Nevada, you'll only have to pay the 15.3% federal self-employment tax rate. An LLC can file paperwork with the IRS to be taxed as an S-Corp or C-Corp instead. Corporations. Corporations are taxed as C-Corp by default. This means that corporations pay the 21% federal corporate tax rate. To pay your federal taxes, and take a good deal of other steps required to start a business, you'll need to get an Employer Identification Number, EIN. You can apply for one with the IRS or hire us to get one for you. Do I need an EIN if I'm self-employed? If you're operating a sole proprietorship or single-member LLC that doesn't employ anyone else and you don't need to file excise or pension plan returns, you don't legally need an EIN. However, you can still get one, and you probably should. Otherwise, you'll have to use your own Social Security number to do business. Plus, you'll likely need an EIN to open a business bank account. How to start a business in Delaware. Delaware is one of the more popular states to form a business, in large part because starting a business in Delaware can help you maintain privacy and save on taxes. They don't call it the home of tax-free shopping for nothing. Technically, forming a business is as easy as making a sale. But if you're in it for the long haul, you're probably thinking about liability protection, legal requirements, and turning a profit. In this guide, we'll cover all that and more. 1. Pick a business structure. The easiest business entity to form is a sole proprietorship. All you have to do is sell something. Selling handcrafted pottery online? You're a sole proprietor. Selling it with a friend? You have a general partnership. In either case, your personal finances are the same as your business finances. This means that if anyone sues your business or if your business goes into debt, your personal assets, house, car, savings, are all vulnerable. To avoid mixing personal and business finances, you'll have to form your business as a separate entity. As such, your business is financially independent and carries its own liability. The most common business entities are LLCs and corporations. Delaware Limited Liability Company, LLC. An LLC will give you options when it comes to structuring your business. While you can choose to run day-to-day operations yourself, you can also choose to hire managers. An LLC can also elect to change its default tax status. To start a Delaware LLC, you'll have to file formation papers with the Delaware Division of Corporations. Delaware corporations must follow strict rules when it comes to record-keeping and management structure. For example, all corporations are made up of officers, think CEO, CFO, etc., and these officers are appointed by board members, who themselves are elected by shareholders. These layers of accountability can be attractive to investors and donors. To form a Delaware corporation, you'll need to file paperwork with the Delaware Division of Corporations. Can an LLC be just one person? Yes. A one-person LLC is called a single-member LLC. Single-member LLCs are one of the most common kinds of businesses in the country. For the most part, single-member LLCs are just like multi-member LLCs, but there are some slight differences in how they file taxes and protect personal assets. What about a Delaware nonprofit? 2. Name your business. Naming a business takes more than creativity. You'll also have to follow Delaware's business name requirements. If you're a sole proprietor, for example, your business name will be the same as your own first and last name, Michael Lee, unless you register a DBA name for your business, Michael's Coffee Shop. LLCs and corporations have to follow even more specific rules. The name of your LLC or corporation must use the correct entity identifier, like LLC for a limited liability company or Inc. for a corporation. Be distinguishable from other business names registered in Delaware. Not use words, acronyms, or phrases that describe government agencies, like ambulance or FBI. Not use words that falsely indicate a business purpose like charity or nonprofit, unless you're forming a charity or nonprofit. Not use words that describe a service requiring a professional license, like dentist or nurse. Find out if your desired name is available in Delaware by searching the Delaware Business Database. Can I reserve a business name in Delaware? Yes. Reserving your business name may be helpful if you're dead set on a particular name, but you're not yet ready to file paperwork with the state. To do this, file a name reservation application, $75, with the Delaware Division of Corporations. This will put a specific business name on hold for you for up to 120 days. You can even file a name re-reservation application to extend for another 120 days, should you need to. What is a DBA? What about trademarked names? 3. File formation paperwork. Sole proprietors and general partnerships don't need to file formation paperwork with the state because neither business type is an independent entity. However, both sole proprietors and general partnerships need to obtain a general business license to legally operate in Delaware. LLCs and corporations, on the other hand, need to file formation paperwork. Filing formation documents with the Delaware Division of Corporations is what makes these business entities official. To start a Delaware LLC, file Delaware Articles of Organization. To form a Delaware corporation, file Delaware Articles of Incorporation. In addition to providing information about your LLC or corporation, you'll need to include the name and address of a Delaware registered agent, someone to handle legal notices on behalf of your business. You can send the completed form to the Delaware Division of Corporations online, by mail, or in person. Note, as one of the more business-friendly states, Delaware formation documents require minimal information. You'll also be asked to provide a cover letter with the name, address, phone number, and email address of your submitter, but this will not become part of the public record. How can I keep my information off the public record? Delaware makes it easy for businesses to maintain privacy. LLC filings won't include any personal information, and corporate filings only ask for the name and address of an incorporator. If you hire a registered agent service, like MyNewNetworth.org, you can use our name instead of your own. What is a registered agent? 4. Draft internal records. So far in this guide, we've dealt with public forms that you've had to file with the Delaware Division of Corporations. Now, it's time to organize your internal records. These are the documents your business will keep on record within your company. Though these documents are internal, you'll likely need to show them to third parties like the bank or, if you start a nonprofit, the IRS. Here are the major internal documents you need to organize for LLCs and corporations. Delaware LLC Operating Agreement. This is your LLC's rulebook. It defines how your LLC will do things like make decisions, distribute money, manage operations, and appoint officers. Your operating agreement plans for every big picture scenario your LLC is likely, or unlikely, to face, including dissolution. Drafting an operating agreement is hard, and the internet is full of shabby templates that have been copy and pasted from who knows where. So we had our attorneys draft a Delaware LLC operating agreement template that you can use as a solid foundation. Delaware Corporate Bylaws. Bylaws are the rules your corporation will adopt and follow internally. Bylaws detail how your corporation will appoint directors and officers, hold shareholder and board meetings, and handle emergencies, among other things. Unlike operating agreements, corporate bylaws are required by law in Delaware. See 8 DE Code Section 109. As with operating agreements, you can find plenty of bylaws templates online. But bylaws are pretty serious, so you don't want to just use the first template you come across. Our attorneys drafted a Delaware corporate bylaws template you can use to get started. 5. Get Delaware business licenses. All businesses in Delaware need a business license, even sole proprietors. Depending on the scope of your business, you may need additional licenses, too. Delaware State Business License. If you conduct business in Delaware, you must apply for a business license with the Delaware Division of Revenue. This is how the state keeps track of businesses for state tax purposes. Professional business licenses. You'll need a professional license if you offer a service in a regulated profession, like medicine, law, or engineering. For a full list of professional services, see 8DE Code Chapter 6. To get a license in your profession, you'll probably have to go through specialized training or education. Once you do, and if you pass, you can apply for a license through the state board that regulates your profession. The application process may look different for each profession. Local business licenses. Whether or not you need a local business license will depend on the type of business you operate, as well as where it's located. For example, if you own a building, you'll need to reach out to your county office, either in Kent, Newcastle, or Sussex, for information on building and/or zoning permits. And if you plan to work on any sewage lines in Sussex County, specifically, you'll need a plumber license. Municipal licenses and/or permits can be issued at the county, city, or town level, and requirements vary by municipality. To find out what's required for your business, it's best to reach out to each municipality directly. How do I get a Delaware business license? You can easily obtain a state business license through Delaware One Stop, the state's licensing portal. The application process will require basic information, like your business name, entity type, address, and must be completed online. How much does it cost to get a Delaware state business license? How do I get a professional license in Delaware? How do I get a local business license? 6. Organize your money. The liability protection you get from forming an LLC or corporation is only as strong as the separation between you and your business. At a minimum, you'll need to open a bank account for your business. And if you're going to hire employees, you'll need to tackle payroll, too. Open a business bank account to keep your business spending separate from your personal spending. You'll need to open a business bank account. If you don't, a court could find that your business is not actually separate from you, the owner, under the alter ego doctrine. Also known as piercing the corporate veil, this is the outcome when a judge finds that a company is not a separate entity but rather an alter ego of the owner. If this ever happens, you could lose your limited liability status. Opening a business bank account as a sole proprietor is important, too. Though sole proprietors and general partnerships have no limited liability status to protect, both will benefit from organizing their business finances come tax season. How do you set up a business bank account? LLCs and corporations will need to provide the bank with their formation documents, operating agreement or corporate bylaws, EIN, and in some cases, a corporate resolution to open a bank account or LLC resolution to open a bank account. Do I need a business bank account to accept credit card payments? Set up payroll. Setting up payroll will be a necessary step for your business if you're planning to hire employees or independent contractors. To do so, you'll need to apply for an EIN, get a Delaware Business Entity File Number, find your employer unemployment insurance, UI, contribution rate, determine whether you'll hire employees or independent contractors, prepare payroll forms for your hires to complete, select a payroll service or software, decide on a payroll schedule. You can decide to run payroll yourself, but then you'll be solely responsible for calculating, withholding taxes, and getting payments out on time. A payroll service or software system will do both automatically, in addition to filing state and federal returns on your behalf. Either option will also issue payments using direct deposit or old-fashioned check, whatever you prefer. Though Delaware encourages direct deposit for all businesses, the state can't legally enforce it. What forms do my employees need to fill out? Your new employees will need to fill out a W-4 to determine how much you'll withhold and an I-9 to verify that the employee is eligible to work in the U.S. What's the difference between an independent contractor and an employee? How do I get a Delaware business entity file number? 7. Get business insurance. Forming an LLC or corporation protects your personal assets. But if anything disastrous befalls your business, like a lawsuit, burglary, flood, or fire, your business is on the hook to pay. Business insurance can help cover the costs. That said, whether or not you need business insurance is another story. Delaware requires businesses to obtain some forms of insurance, but not others. As for those others, it's a gamble. Whether or not you choose to buy comprehensive insurance for your business depends, in large part, on the level of risk you're willing to take. Here's a breakdown of the most commonly purchased business insurance. Workers' compensation insurance. Delaware requires pretty much all businesses with one or more employees to pay for workers' compensation insurance. The only exceptions to this rule are domestic workers and farm workers, though their employers may provide coverage if they choose to do so. All other businesses must purchase workers' compensation insurance from a private insurance company, or, if coverage is difficult to secure for your business, you can contact the Delaware Compensation Rating Bureau to apply for coverage through the Delaware Insurance Plan, DIP. Businesses that don't provide workers' compensation benefits for their employees, but are required to do so, will be subject to fines between $500 and $2,500. Liability insurance. This covers the costs of claims against your business for injuries or damages to the property of others, like clients or customers. This includes medical expenses, legal fees, settlements, and judgments. Whether or not you need it depends on whether your business is likely to be sued and how many assets your business needs to protect. If it's just you and your computer in your basement, you might feel comfortable skipping liability insurance. Or maybe you won't. Beyond general liability insurance, you can purchase or add on more specific types, like professional, cyber, commercial, home-based business, or product liability insurance. Do business owners need workers' compensation insurance in Delaware? In most cases, yes, Delaware workers' compensation laws apply to both employees and employers. However, as many as 8 corporate officers or 4 LLC members may choose to be exempted from coverage, so long as there is a written agreement between the business and the individuals foregoing coverage. Do I need business insurance for my home-based business? 8. Understand your tax burden. Not only does Delaware respect business owners' privacy, it doesn't enforce state or local sales tax. This makes Delaware a very favorable place to do business. However, this doesn't mean you won't have to pay any taxes. There are other state and local taxes to consider, not to mention federal taxes. Federal taxes. LLCs. Single-member LLC. By default, you're taxed similar to a sole proprietor. More than one LLC owner? You're taxed as a general partnership. Either way, your default tax status is pass-through, which means you don't pay corporate taxes. Instead, your LLC's owners report profits and losses on their personal tax returns. An LLC can file paperwork with the IRS to be taxed as an S-corp or C-corp instead. Corporations. Corporations are taxed as C-corp by default. This means that corporations pay the 21% federal corporate tax rate and the applicable Delaware corporate tax rate. To pay your federal taxes, and take a good deal of other steps required to start a business, you'll need to get an employer identification number, EIN. You can apply for one with the IRS or hire us to get one for you. Do I need an EIN if I'm self-employed? If you're operating a sole proprietorship or single-member LLC that doesn't employ anyone else and you don't need to file excise or pension plan returns, you don't legally need an EIN. However, you can still get one, and you probably should. Otherwise, you'll have to use your own Social Security number to do business. Plus, you'll likely need an EIN to open a business bank account. How do I get an EIN? What is an S Corp? What is a C Corp? Local Delaware business taxes. Unlike most states, Delaware does not impose a local sales tax in any municipality. In lieu of paying sales tax, businesses are required to obtain business licenses at the state level, as well as in some local jurisdictions, such as Dover, Newark, and Newcastle, to name a few. The city of Wilmington, Delaware's largest, even requires an earned income tax, or city wage tax, which is basically a tax for living and/or working in the city. In short, you should contact your local municipality to find out whether you'll have any local tax obligations. 9. Build your business website. If you want people to find your business, they have to be able to find you online. This means you'll need a website, a business email account, and social media accounts. Don't worry if you're not especially tech-savvy, you don't have to be a web developer or an influencer to establish a robust online presence. You'll just need the following. Domain name. Your domain is the address where your website will live. You'll want a domain name that is short, unique, local, and, most importantly, available. If your domain is trademarked, you could face legal trouble. Domain registrar. Once you've decided on a domain name, you'll want to register it with a domain registrar. Some domains are more expensive than others. Some domain registrars also offer hosting, and most will provide you with a business email that includes your domain name, nameatyourbusiness.com, nameatyourbusiness.com. SSL certificate. An SSL certificate signals to your users that your website is secure. If your website will use forms, like a sign-up form or a contact us form, an SSL certificate is critical. But even if you don't use forms, you'll still probably want one. It allows an encrypted connection, which means your user's data is transported securely. There are several types of SSL certificates, and you can often get one through your domain registrar. Site design. The easiest option is to use a free website creation tool. There are a number of free options available. Most are easy even for a newcomer to use, with styles and built-in templates. For a more custom design, you can hire a web designer to work on your website, but this will be much more expensive. 10. File a Delaware annual report/franchise tax. Delaware corporations are required to file an annual report and pay franchise tax. Foreign corporations, however, need only file an annual report. LLCs have to pay an annual tax of $300. You read that right, no annual reports for Delaware LLCs, but a pretty hefty annual tax. For domestic Delaware corporations, the annual report is pretty simple. It only requires you to provide and/or update basic information about your business, like your address and director/officer information. You will also provide franchise tax information in your annual report. All state tax-related filings, annual report, franchise tax, annual tax, must be made online. Through the Delaware Corporations Information System, DSIS E-Corp. Domestic corporations must complete their filings by March 1st, foreign corporations by June 30th, and all LLCs by June 1st. How to start a business in Wyoming? Want to know how to start a business in Wyoming? Look no further. This guide will give you all the ins and outs on forming your LLC or corporation in the Cowboy State. Between having no corporate income tax and no minimum capitalization, Wyoming is an enticing state for business owners. Plus, Wyoming corporations have the option to issue an unlimited number of stock, great for anyone looking for multiple investors. If you're looking to start a business in Wyoming, keep reading. We'll tell you everything you need to know to form a business in Wyoming and protect your personal assets. 1. Pick a business structure. Choosing the right structure for your business is the first big decision you have to make. Though it might seem overwhelming at first, Let's break down the different business structures and why you might choose them. Sole proprietorships and general partnerships require no formal paperwork to be submitted with the Secretary of State. It really is as easy as just selling something. So why wouldn't people always choose these low-maintenance businesses? Well, sole proprietorships in general. Partnerships have no liability protection, meaning that the business and the owner are not separate legal entities, and the business's debts are also the owner's debts. Many business owners choose to form as an LLC or corporation for the financial and safety benefits of liability protection. Let's go over the differences between an LLC and a corporation. Wyoming Limited Liability Company, LLC. Wyoming LLCs are a popular business entity choice. Not only do they have liability protection, meaning that the business is a separate legal entity from you, but they offer a ton of flexibility in both management and taxation. Management-wise, LLCs offer flexibility by allowing pretty much anyone to be in charge. You can run the business yourself, appoint someone from within the business, or hire an outside manager to be in charge. There's no formal board to approve this like with a corporation. Additionally, LLCs have flexible taxation. LLCs are pass-through entities by default. This means that the business doesn't pay entity-level taxes, and instead the profits are taxed when they are distributed to the members. However, an LLC can choose to be taxed as a C Corp or an S Corp instead. Wyoming LLCs are a popular choice, especially for small business owners. To start a Wyoming LLC, file your Articles of Organization with the Secretary of State. What about Decentralized Autonomous Organizations, DAO, LLCs? Wyoming and Tennessee are currently the only states that currently allow you to form a Decentralized Autonomous Organizations, DAO, LLC, meaning that DAOs cannot have liability protection in other states. A DAO LLC is, essentially, a business ran with and by technology that has a flat organization, rather than hierarchical organization like a traditional company. The DAO is hosted on a blockchain, and everyone involved has equal voting rights. Since a DAO uses machine algorithms to make decisions, human input is limited or sometimes non-existent after the initial formation. This is also called a smart contract, or an automated transaction. This means that, as the name implies, the DAO LLC is a limited liability company that is decentralized and autonomous. You can form a DAO LLC the same way you would a regular LLC. You simply must include the words DAO or LAO in the business name and mark on your LLC application that the business will be a DAO LLC. Wyoming Corporation. While corporations lack the flexibility of LLCs, they still have liability protection. Plus, corporations have the added benefit of investor interest. Because corporations have a more structured management system and taxation, donors and investors are often more willing to financially support corporations. Wyoming corporations are a great choice for owners looking to grow their business quickly. To start a Wyoming corporation, file your Articles of Incorporation with the Secretary of State. Can an LLC be just one person? Yes. A one-person LLC is called a single-member LLC. Single-member LLCs are one of the most common kinds of businesses in the country. For the most part, single-member LLCs are just like multi-member LLCs, but there are some slight differences in how they file taxes and protect personal assets. What about a Wyoming nonprofit? 2. Name your business. The process for naming your business in Wyoming is simple. Come up with a name. Make sure it fits with all the legal requirements for business names in Wyoming, and submit your name on your business's formation documents. Keep in mind that even if you already have a name in mind, the business name must follow the state requirements. According to Wyoming business statutes, your business name must include a designation, such as LLC, Limited, or Company for an LLC and Corporation, Corp, or Inc. for a corporation. Not use words that describe other professional businesses. For example, you can't use the words insurance and charity if you do not, in fact, have an insurance company or charity, be an entirely unique, meaning it can't be identical or similar to an existing business. Search the Wyoming Secretary of State website to see if your business name is available. Can I reserve a business name in Wyoming? Yes, you can reserve your desired business name in Wyoming. To reserve an LLC name or to reserve a corporation name, you simply have to fill out the reservation form and submit it to the Secretary of State along with the $60 filing fee. You can only officially claim your business name by filing your formation documents, but the reservation keeps the name available for you for 120 days while you get ready. What is a trade name? What about trademarked names? 3. File formation paperwork. To start an LLC or corporation in Wyoming, you need to file formation paperwork. Your formation paperwork is submitted to the Wyoming Secretary of State. If you are a sole proprietor or general partnership, you won't need to file paperwork with the state. To form a Wyoming LLC, file Wyoming Articles of Organization. To start a Wyoming corporation, file Wyoming Articles of Incorporation. For both LLCs and corporations, your formation paperwork costs $100 to file and requires you to list out your business's name, principal address, and registered agent. You can apply on the Wyoming Secretary of State website or via the paper form. What is a registered agent? A registered agent is a person or business that accepts legal mail on your business's behalf. The business must be in good standing, available during regular business hours, and able to quickly inform you of a service of process. Your registered agent must also have a physical location in the state of Wyoming. While an individual can be your business's registered agent, most business owners choose a registered agent service like mynewnetworth.org. How can I keep my information off the public record? 4. Draft internal records. So far in this guide, we've dealt with public forms that you've had to file with the Wyoming Secretary of State. Now, it's time to organize your internal records. These are the documents your business will keep on record within your company. Though these documents are internal, you'll likely need to show them to third parties like the bank or, if you start a nonprofit, the IRS. Here are the major internal documents you need to organize for LLCs and corporations. Wyoming LLC Operating Agreement. This is your LLC's rulebook. It defines how your LLC will do things like make decisions, distribute money, manage operations, and appoint officers. Your operating agreement plans for every big picture scenario your LLC is likely, or unlikely, to face, including dissolution. Drafting an operating agreement is hard, and the internet is full of shabby templates that have been copy and pasted from who knows where. So we had our attorneys draft a Wyoming LLC operating agreement template that you can use as a solid foundation. Wyoming corporate bylaws. Bylaws are the rules your corporation will adopt and follow internally. Bylaws detail how your corporation will appoint directors and officers, hold shareholder and board meetings, and handle emergencies, among other things. Unlike operating agreements, corporate bylaws are required by law in Wyoming. As with operating agreements, you can find plenty of bylaws templates online. But bylaws are pretty serious, so you don't want to just use the first template you come across. 5. Get Wyoming business licenses. You need to get your Wyoming business licenses all squared away before you start your business. This means understanding your state, professional, and local business license requirements, submitting your applications, and receiving approval from the appropriate agencies. Not sure where to get started? Let's go over how to get your Wyoming business licenses. Wyoming State Business License. In Wyoming, all businesses are required to have the sales and use tax license. This license gives businesses permission to sell products, goods, and services. You must submit your sales/use tax license application and receive approval from the Wyoming Department of Revenue prior to accepting sales at your business. For all other business licenses, check your profession's requirements and your local area's mandatory licenses. Professional business licenses. Professional business license policies depend on a few things, such as your business entity, industry, and size. Here's a breakdown of the most commonly purchased business insurance. Workers' compensation insurance. The state of Wyoming requires workers' compensation insurance from nearly all Wyoming employers. Workers' comp covers things like medical bills, temporary disability, lost wages, and death benefits for employees injured or killed on the job. Every business, regardless of exemption status, will need to register with the Division of Workers' Compensation and Unemployment Insurance in order to have their coverage determined by the state. Generally speaking, casual laborers, private household employees, and volunteers are not required to have workers' compensation coverage. The Workers' Compensation Act (WS) Sections 27(14) to 101 outlines the specifics for coverage requirements. Unlike other states, there is no self-insured option for business owners in Wyoming. All employers must purchase coverage from the Wyoming Workers' Compensation Program or from a state-chosen third-party insurer if your business does not qualify for the state program. Liability insurance. This covers the costs of claims against your business for injuries or damages to the property of others, like clients or customers. This includes medical expenses, legal fees, settlements, and judgments. Whether or not you need it depends on whether your business is likely to be sued and how many assets your business needs to protect. If it's just you and your computer in your basement, you might feel comfortable skipping liability insurance. Or maybe you won't. Beyond general liability insurance, you can purchase or add on more specific types, like professional, cyber, commercial, home-based business, or product liability insurance. Do business owners need workers' compensation insurance in Wyoming? Not necessarily. Sole proprietorships, partners, LLC members, and corporate officers do not need to have workers' compensation coverage for themselves. However, you might choose to purchase coverage anyway. Personal health insurance providers might decline any work-related injury, so having workers' compensation coverage could keep you from having to pay out of pocket for any work-related injuries. Do I need business insurance for my home-based business? 8. Understand your tax burden. Wyoming business taxes are made a bit easier by the complete lack of corporate and personal income tax. Woo! Still, there are taxes to be paid. Let's go over the federal, state, and local business taxes you'll need to pay in Wyoming. Federal taxes. LLCs. Single-member LLC. By default, you're taxed similar to a sole proprietor. More than one LLC owner? You're taxed as a general partnership. Either way, your default tax status is pass-through, which means you don't pay corporate taxes. Instead, your LLC's owners report profits and losses on their personal tax returns. Good news, because there's no state income tax in Wyoming, you'll only have to pay the 15.3% federal self-employment tax rate. An LLC can file paperwork with the IRS to be taxed as an S-Corp or C-Corp instead. Corporations. Corporations are taxed as C-Corp by default. This means that corporations pay the 21% federal corporate tax rate. To pay your federal taxes, and take a good deal of other steps required to start a business, you'll need to get an employer identification number, EIN. You can apply for one with the IRS or hire us to get one for you. Do I need an EIN if I'm self-employed? If you're operating a sole proprietorship or single-member LLC that doesn't employ anyone else and you don't need to file excise or pension plan returns, you don't legally need an EIN. However, you can still get one, and you probably should. Otherwise, you'll have to use your own Social Security number to do business. Plus, you'll likely need an EIN to open a business bank account. How do I get an EIN? What is an S-Corp? What is a C-Corp? Wyoming state business taxes. Wyoming does have a 4% sales tax and a 9.5%, on average, property tax. Importantly, Wyoming has an annual business fee attached to all in-state assets, which might seem like a tax. This is either $60 or $0.0002 for every dollar of your Wyoming assets, whichever is greater. Local Wyoming business taxes. Wyoming has a local sales tax on top of the state sales tax that varies city to city and county to county. For example, in Cheyenne, the city assesses a 2% sales tax in addition to the 4% from the state. So, in total, you'll pay 6% in sales tax. 9. Build your business website. If you want the good people of Wyoming to find your business, they have to be able to find you online. This means you'll need a website, a business email account, and social media accounts. Don't worry if you're not especially tech-savvy, you don't have to be a web developer or an influencer to establish a robust online presence. You'll just need the following: domain name. Your domain is the address where your website will live. You'll want a domain name that is short, unique, local, and, most importantly, available. If your domain is trademarked, you could face legal trouble. Domain registrar. Once you've decided on a domain name, you'll want to register it with a domain registrar. Some domains are more expensive than others. Some domain registrars also offer hosting, and most will provide you with a business email that includes your domain name, nameatyourbusiness.com, nameatyourbusiness.com. SSL certificate. An SSL certificate signals to your users that your website is secure. If your website will use forms, like a sign-up form or a contact us form, an SSL certificate is critical. But even if you don't use forms, you'll still probably want one. It allows an encrypted connection, which means your user's data is transported securely. There are several types of SSL certificates, and you can often get one through your domain registrar. Site design. The easiest option is to use a free website creation tool. There are a number of free options available. Most are easy even for a newcomer to use, with styles and built-in templates. For a more custom design, you can hire a web designer to work on your website, but this will be much more expensive. 10. File a Wyoming annual report. All Wyoming LLCs and corporations must submit an annual report. This is due on the first day of their anniversary month of formation, so if you started your business on October 26, 2020, you'll need to submit your annual report by October 1st each year. Your filing fee, also called the Wyoming Business License Tax, is determined by your total assets within the state. You will pay either $60 or $0.0002 for every dollar of your in-state assets, whichever is greater. You can submit your annual report on the Wyoming Secretary of State online portal or via paper form in the mail. If you submit online, you will need to pay a convenience fee. How to merge LLCs. Question: Hello, I am interested in merging two LLCs. Is this possible? Thank you to one of our customers for a great question. An LLC merger is when two or more LLCs combine to form a single LLC. While the exact process of merging may vary from state to state, here's how it typically works. Step 1. Create a plan of merger according to the Uniform Law Commission's Limited Liability Act, versions of which have been adopted by 19 states and the District of Columbia. The first step to merging LLCs is creating a plan of merger. This plan should be drafted by members of both LLCs. Before drafting your plan, you'll need to know if your LLCs are combining to form a new LLC or if one LLC will absorb the other. Either way, the LLC resulting from the merger is referred to as the surviving LLC. Your plan of merger should contain the name, jurisdiction of formation, and entity type of each original LLC, the surviving entity's name, jurisdiction, and entity type, information on how the interests of each party will be converted to the surviving LLC, and in what form, money, property, etc. If the surviving LLC existed before the merger, any proposed amendments to its public or internal records, for example, its articles of organization and operating agreement. If the surviving entity will be a new LLC, the new articles of organization and new operating agreement. Any additional provisions required by your jurisdiction. Any other provisions that your LLC's members wish to add. Step 2. Approve the merger. Once your plan of merger is completed, all LLCs involved must approve the plan. Depending the rules laid out in your LLC's operating agreements, this could look different for each LLC. However, generally speaking, the members of each LLC must convene and vote to approve the merger. Step 3. File a statement of merger. After you have every aspect of the merger ironed out internally, you're ready to make your merger official with the state. That means filing a statement of merger. Your statement of merger should include the name, jurisdiction of formation, and entity type of each LLC that will not survive the merger, the name, jurisdiction of formation, and entity type of the surviving LLC, a statement that the merger was approved by all LLCs involved, any amendments to either LLC's original articles of organization and operating agreement or your new articles of organization and operating agreement, your plan of merger, signed by the members of all merging LLCs, any additional provisions required by your jurisdiction, any other provisions that your LLC members wish to add depending on the state. You may need to pay a filing fee when you submit your statement. Fees vary by state. Once the state has approved your statement of merger, you're ready to go. Step 4. Dissolve original LLCs and register new LLC. Finally, you'll need to dissolve all non-surviving LLCs by submitting statements of dissolution to the Secretary of State or other agency in charge of business registration where your LLCs are located. This will officially close these businesses. If your surviving LLC is a new business entity, you'll need to file new articles of organization to officially register your new LLC with the state and legally start doing business. Steps to take after you merge LLCs. When your LLCs merge, you are either absorbing one LLC into the other or creating a whole new LLC. That means you'll need to inform everyone you do business with of this change. Here are some steps you'll need to take. Update or change bank accounts. Contact your vendors. You may also need to appoint a new registered agent if you won't be keeping the one of the registered agents from the original LLCs as the registered agent of the surviving or new LLCs. Do I need a new EIN when I merge LLCs? It depends. If one of your original LLCs will continue to exist as the surviving LLC, you can continue to use that LLC's EIN. However, if you form a new LLC, you'll also need to get a new EIN because you'll be operating as a new business entity. Best of luck! Can an out-of-state business be an LLC member? Question: can a business entity be a member of my LLC, and does it matter if the entity is from another state? Thank you to a customer for that great question. Yes, LLC members can be either individuals or business entities, such as LLCs or corporations. The business entity does not have to be formed in the same state or jurisdiction as your LLC in order to be a member. What is an LLC member? An LLC member is an owner of an LLC, similar to a shareholder of a corporation. Members contribute money, property, or services to an LLC to pay for their membership interest. Typically, the amount you contribute to the LLC correlates to the percentage of membership interest you own. For example, if one member contributed $6,000 and a second member contributed $4,000, the first member would have a 60% membership interest, and the second member would have a 40% interest. However, you can divide membership interest differently in your LLC operating agreement, if you choose. Why would I want an LLC or corporation to be a member of my LLC? The most common reason why business owners create an LLC owned by another LLC or a corporation is to create a holding company. A holding company is a business entity that doesn't sell any products or services but exists simply to control another company and hold assets. The benefit of a holding company is additional liability protection. If the subsidiary, the business the holding company controls, goes bankrupt, creditors can't go after the holding company's assets. Who can't be a member of an LLC? There are some cases in which a business entity usually can't be a member of an LLC, including PLLCs and S-Corp. In the case of PLLCs, professional limited liability companies, members are typically required to be licensed professionals. So for example, if your PLLC was a dentistry practice, all members would most likely be required to be licensed dentists. However, the rules for PLLCs vary by state. If your LLC is taxed as an S-Corp, one of the requirements for S-Corp status is that all members must be individuals, with a few exceptions. So you would most likely not be able to have a business entity as a member of your LLC if you plan to apply for S-Corp tax status. Do I need to disclose who my LLC members are? It depends on where you form your LLC. Some states require you to include your members' names and addresses on the LLC Articles of Organization, whereas others do not. Even if the state where you are forming your LLC does require you to list member information, you can help protect your privacy by hiring a registered agent service that agrees to put their business address on public business filings instead of your members wherever possible. Factors to consider when choosing a state. With 50 states and D.C., numerous factors ultimately contribute to choosing the best state for your LLC. Fees. It costs money to form and maintain an LLC. Filing articles of organization with the state ranges from $40, Kentucky, to $500, Massachusetts. Some states charge exorbitant annual report fees as well. Looking at you again, Massachusetts, while states like New Mexico and Arizona don't require LLC renewals or reports at all. And then there's business licensing and permit fees. Costs add up much faster in some states than others. Privacy. Some states are considered anonymous LLC states where you can form an LLC business entity without providing the identity of the owners, members, or managers on public state filings. States known for their privacy include Delaware, Wyoming, New Mexico, and Nevada. Having an anonymous LLC can prevent unwanted individuals from having public access to your private information. Taxes. Some states have really advantageous tax laws. Just remember that in most cases, taxes are paid where money is made. So, even if your LLC is formed in a state with great tax laws, you may not be able to take advantage of them if all your business is done in your home state. Even worse, you may owe additional taxes and fees wherever you formed your LLC. States like California and Vermont have LLC franchise taxes just for doing business in the state. Liability protection from lawsuits. The primary reason that people form LLCs is to avoid personal liability from lawsuits or the debts of the business. When you form an LLC, only the LLC is liable for the debts and liabilities incurred by the business, not the owners or managers. However, some states have stronger legal limitations for creditors, which can better protect your LLC and its assets. Generally, forming an LLC in your home state will save you time and money. In fact, most LLC formation experts agree that forming an LLC where you live and where you plan to do business is your best bet. However, there are a few states out there that go above and beyond to provide particularly favorable conditions for LLCs. If you're willing to throw off conventional wisdom and go all in on the state that best meets your LLC's needs, then this list is for you. Best state to form an LLC for an online business. Whether you're selling birdhouses on Etsy or books on eBay, running an online business is less about where your customers live and more about where you run your business from. As with a Brick-and-mortar business. If you are based in your home state, you'll do best with a home state LLC. Registering an LLC in Wyoming won't mean you can avoid California taxes if your LLC is actually based in California. That said, maybe you're operating from out of the country, have the freedom to move wherever is best for your business, or just want to know how your state measures up. Wyoming is the runaway winner in this category with low startup costs, low annual report fees, low taxes, and robust liability and privacy protection. Sure, Delaware and Nevada are the big dogs when it comes to business formation, but Wyoming offers basically everything they do, and beats them both when it comes time to pay the piper. Hard to beat a one-time $100 LLC filing fee and a $60 annual report, especially when Delaware and Nevada charge hundreds each year just for the privilege of having an LLC in their states. Winner, Wyoming. Best state for LLC asset protection. Nevada, Delaware, and Wyoming are well known for having superior asset protection codified in their state laws, where a charging order is the sole remedy to pay the debts of the LLC. A charging order is similar to the garnishment of wages, but in this case it is applied to an LLC and is usually limited to the dollar amount of the judgment. In many states, statutes don't expressly limit the rights of creditors. So, in states like Indiana and Missouri, personal creditors could potentially force the sale of an LLC's assets. In states with strong charging order protections, creditors cannot force the sale of the LLC's assets to satisfy debts. Tie, Delaware, Nevada, and Wyoming. Best state to form an LLC for real estate. We're going to call this one a tie between Delaware and Wyoming. Both states allow for a series LLC, which can help real estate investors segregate their properties and enhance their liability protection. A series LLC allows real estate investors to create multiple series under the parent LLC to hold properties separately, without the full cost of forming and maintaining additional LLCs. The cost savings and flexibility of the series LLC structure makes it attractive to buy and hold real estate. Not every state allows for series LLCs. Both Wyoming and Delaware offer excellent asset protection and privacy, though a Wyoming LLC will have lower costs than a Delaware LLC, although note that if your real estate is located in Wyoming, the state's annual report charges a percentage of Wyoming-based assets. Tie, Delaware and Wyoming. Best state for anonymous LLCs. Some states are considered anonymous LLC states where you can form an LLC business entity without providing the identity of the owners. States known for their privacy include Delaware, Wyoming, New Mexico, and Nevada. Having an anonymous LLC can prevent unwanted individuals from having access to your private information. One reason Delaware, Nevada, and Wyoming are known for privacy is that they all allow for nominee services. A nominee is essentially a public representative contracted by the LLC to keep owner names more private. However, these services can be expensive, complicated, and sometimes dubious. Delaware, Wyoming, and New Mexico also have a much more straightforward privacy solution. These states don't require ownership information on public filings. While you'll still need to publicly list a registered agent and organizer, you can easily hire a registered agent service and a formation service. If you're a small business that is looking for a mix of low costs and privacy, New Mexico is the cheapest anonymous LLC option. New Mexico has no LLC annual report filing or fee. Winner, New Mexico. Best state for single-member LLCs. Many states do not afford single-member LLCs the same level of protection from creditors as they do for multi-member LLCs. In fact, in some states, recent court decisions have stated that the charging order should not be the creditor's exclusive remedy if there is only one member. This means that a single-member LLC is more in danger of having its assets seized in order to pay debts. The good news is states like Wyoming, Nevada, and Delaware have not budged on their belief that a charging order should be the exclusive remedy to collect debts from both single and multi-member LLCs. This means that single-member LLC owners really need to think long and hard about what state has their back. If you could form your single-member LLC in any state, it'd be smart to look Wyoming's way. Not only does Wyoming have low taxes and a commitment to privacy, it also offers robust asset protection for single-member LLCs. Sure, Nevada and Delaware offer strong protection for single-member LLCs, but Wyoming is more affordable at just $100 to form your LLC and $60 to file the annual report. Winner, Wyoming best state for cryptocurrency LLCs. Although cryptocurrency is a relatively new phenomenon, Merriam-Webster didn't add the term to its dictionary until 2018. Wyoming looks to be the home base, at least for crypto-based LLCs. Wyoming, which has never been keen on excessive regulation, has passed over 20 crypto-focused laws in the last few years that lets digital currency startups test new products and technologies without being overburdened with regulations. Beyond that, Wyoming recently passed SF 0038, which allows for decentralized autonomous organizations, DAOs, to register as Wyoming LLCs. This gives many crypto companies traditional legal protections not found in other states. In doing so, Wyoming laid the foundation for DAOs to be legally recognized and for cryptocurrency LLCs to flourish. Winner, Wyoming best state for LLC taxes. If we're just talking about taxation in a vacuum, then Wyoming and South Dakota take this hands down. With no state corporate income tax, no personal income tax, no inventory tax, no gross receipts tax, and no franchise tax, it's as if these states are allergic to taxation. These states do have sales taxes, and Wyoming's rate averages out to be a little over 5% depending on where you live or purchase your goods, but that's still one of the lower rates in the nation. South Dakota's sales tax rate averages a bit higher but still isn't too bad. Of course, your LLC will really only benefit from the bulk of these tax savings if you live and do business in one of these states. South Dakota and Wyoming. Final thoughts: if you have some flexibility in where to live and conduct business, or if perks like privacy or protection matter more than extra costs and complication, a handful of states are clear winners. While best is always up for debate, the states listed above do bring a little something extra to the table. And at mynewNetworth.org, we can help you start an LLC in any state you'd like. How to form an anonymous LLC. Anonymous LLC isn't its own business entity, but for many business owners, privacy is a top priority. Here's what you need to know about anonymous LLCs. What is an anonymous LLC? An anonymous LLC is simply a regular limited liability company in which the owner is able to maintain personal privacy protections. Owners, aka members, are restricted by the laws in their state, and some states offer better privacy protections than others. These states are often referred to as anonymous LLC states. Which states have anonymous LLCs? The 4 states most often referred to as anonymous LLC states are Delaware, Nevada, New Mexico, and Wyoming. These states, with the exception of New Mexico, offer what's called nominee service, which allows LLCs to put the name of a public representative on its formation documents in lieu of an owner. Delaware, New Mexico, and Wyoming also don't require ownership information on public documents. How do I create an anonymous LLC? You can create an anonymous LLC by selecting a state with strong privacy protections, then going through the regular process of forming an LLC in that state. Just note that when you file your formation papers with the state, they become part of the public record and are thus made available to the public. So best not include your name or address in your articles of organization, unless the state requires it. And if you want to maintain privacy, file in a state that doesn't require it. Live privately with an LLC when you want more. Most Americans have very little functional privacy because we give our privacy up in 100 ways every day, through social media, internet search engines, voting, buying a gun, starting a business, buying a house, buying a car, using a credit card, using a mobile phone, just fill in the blank. Living publicly is so thoroughly baked into the way we do things that most of us don't even give it a single thought, that is, until the day when we're suddenly faced with the consequences of an increasingly public existence. But if you're reading this guide on how to live privately with an LLC, you're probably starting to rethink this public way of life, and you're likely wondering what legal mechanisms exist for you to reclaim your privacy. One option is skillfully using the limited liability company, LLC, to protect your privacy, which is what the following guide is about and where we come in. What do we mean by living privately? By living privately, we mean keeping your personal information away from people who do not need it. This includes data sellers, big tech companies and social media giants, marketers, hackers, hostile foreign governments, political activists, nefarious people looking to file frivolous lawsuits, abusive ex-spouses and so on, people and entities, in other words, that mine the rich field of personal data made public in order to exploit, damage or harass ordinary, decent people who just want to live unencumbered lives. By living privately, we do not mean keeping relevant information away from the IRS, from the federal, state, and local governments, and from courts. That's an important line to draw because such entities do need information about you, even if they often ask too much. But you can render to Caesar the things that are Caesar's, so to speak, without giving the same information to every Joe Schmo with an internet connection and a mobile phone. How? By using services MyNewNetWorth.org provides to keep your name, address, and phone number off of as many public documents as possible, and by placing your most valuable assets in LLCs formed in the right states and in the right way. Myths about wanting to live more privately. First, let's get a basic fact out of the way. You are not a kook simply because you want a more private life. The silly notion that living transparently, such that everyone knows your business, is normal is only a tool for individuals and companies that profit from routinely invading our privacy. It helps them for us to freely give up our personal and business information and believe that's normal, and to believe that anyone who doesn't want to do so is strange. Second, wanting to live more privately isn't a sign that you have something to hide or that you're up to no good. Sure, bad actors, criminals or whatever, also want to live as privately as possible, but so do celebrities, politicians, abuse victims, and people who hold unpopular political views. Heck, maybe you just run a side business and don't want your employer to know about it or interfere. But, importantly, there are degrees of privacy to consider, and not everyone who wants to live a more private life needs, or even wants, precisely the same things. Maybe your goal isn't to disassociate your name from your assets, but to simply keep your phone number and address off of the public record. Well, we can help you there. Or maybe your goal is simply to erect a legal shield between you and your assets, such that if you ever face a lawsuit dealing with one of those assets, say, a piece of commercial real estate, your personal bank accounts and other assets aren't also threatened. Well, we can help you there too. Or maybe you're wanting to go the whole way, protect your assets, yourself, your phone number, your address, and avoid putting your name down on any publicly available documents filed with the state. There are reams and reams of good reasons to do so, but, whatever your reasons, MyNewNetWorth.org can help you there too. So let's say it again, you're not a kook or a bad actor simply because you want to live more privately. Nor are you necessarily up to no good. To us, you just sound like a reasonable human being who is tired of giving up information other people have no valid reason to want in the first place, and we'd like to help. How to live privately with an LLC. At MyNewNetWorth.org, we can help you use the LLC business structure to live more privately, protect your assets, and reduce your public profile. We can form an LLC in any state for $225 plus state fees. This service includes filing your articles of organization with the state, 1 full year of our registered agent service, and the ongoing support of our expert corporate guides. What is an LLC? A limited liability company, LLC, is a legal entity formed in a state jurisdiction that can transact business, own assets, hire employees, sue, and be sued. To start an LLC, you'll need to file a formation document, usually called Articles of Organization, with the state and pay a state filing fee. And you'll need to deal with ongoing filing requirements as well, such as annual or biennial reports, with requirements that vary from state to state. Most of us think in traditional business terms when we hear the term LLC, but an LLC is a legal entity first and foremost. It may be a legal entity that also transacts business in the traditional sense, but it doesn't have to be. An LLC can also serve as a holding company and simply own things, like a person, because legally it is a person, which means you can form an LLC that owns a house, a car, an RV, a boat, or whatever. If you properly maintain your LLC, it creates a legal shield between you and the assets owned by the LLC. So if your LLC ever gets sued, your other assets, not held by the LLC, won't be on the line. Likewise, if you ever get sued, for whatever reason, the assets owned by your LLC won't be on the line either. Of course, simply forming an LLC for the sake of asset protection won't protect every aspect of your privacy on its own in most states. An LLC needs one or more owners, called members, and your ownership information will eventually appear on public filings in most states unless you take concrete steps to prevent it. LLCs and privacy. To use an LLC to protect your privacy, you have to make sure your public filings for the LLC don't list your name or address. When it comes to the address on your public filings, that's fairly easy. You can use our address in place of yours when you hire us to form your LLC, and you can sign up for our mail forwarding service if you want to use our address for your mail and for any member or manager information required by the state. When it comes to keeping your name off of public filings, things can get more complicated. In that case, you have three main options. 1. You can form your LLC in a state that doesn't require ownership information to be listed on any public filings, currently only New Mexico, Delaware, and Wyoming. That's easy, of course, if you live there, and complicated if you don't. 2. In some states, you can form your LLC as manager managed and hire a nominee or nominee service to put its name as manager. 3. Or you can form two LLCs, one LLC in a state that doesn't require ownership information, again, New Mexico, Delaware, or Wyoming, and one LLC in your home state. In this case, the out-of-state LLC can be the owner, the member, of your in-state LLC. Of course, the more complex your LLC setup gets, the more costly it gets as well. If you live in Texas and form a Wyoming LLC to buy a house in Texas, for example, you'll need to register your Wyoming LLC as a foreign business entity in Texas, which means you'll pay fees associated with each state and for each LLC you form. The same thing is true if you register the LLC that owns your house in Texas and start a separate LLC in Wyoming, or another privacy-friendly state, that can then own your Texas LLC. Here, it's best to think of privacy as coming in degrees and consider the degree to which you want to protect your privacy. If your goal is to simply protect your assets and protect your address, starting an ordinary LLC combined with our mail forwarding service will cover most of your needs in a simpler, less costly way. If your goal is to live as privately as possible, however, you'll likely need to avail yourself of the more complex and more costly options available, such as the dual entity strategy of forming multiple LLCs. How to get an EIN without an SSN. EINs are free and easy to obtain with a Social Security number, SSN. Or, if you don't have an SSN, you may get an EIN by following these steps. How do I get an EIN without an SSN? If you don't have an SSN, you'll need to use Form SS-4 to obtain an employer identification number from the IRS. You'll fill out basic information about your business name, entity type, location, then mail the completed document to the IRS.